be seated, please. Okay, Ms. Prevett, anything before we bring the jury back in?
No, Your Honor.
Mr. Kirkhoff?
Oh, yeah.
All right, very good. Let's do it. All rise for the jury, please. Be seated, please. All right, ladies and gentlemen, first of all, I want to thank you for your promptness again. I told you to be here at 8:15, in the building. You were in the jury room at 8:15 yesterday. I told you to be here at 8:30 today. You were in the jury room at 8:30, which means you guys have been very prompt. 14 people got here on time. Next time I have an attorney that's 10 minutes late for court, I'm going to tell them about you guys. In any event, I believe we're going to finish up the evidence this morning and then have arguments and instructions later. How long that will take, I'm not quite sure. We're going to have to see how it goes. Ms. Prevett, please call your next witness.
Thank you, Your Honor. The people called Detective Adam Bayless.
Sir, please raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Very good. Have a seat, please. Go ahead, Mr. Prevett.
Thank you, Your Honor. Good morning.
Good morning.
Could you please state your name for the record and also spell it?
Adam Bayless, last name spelled Baylis, as in Sam.
Thank you. How are you currently employed?
I am a police officer with the Grand Rapids Police Department.
How long have you worked in that capacity?
Over 26 years.
What is your current assignment?
I am in the detective unit, part of the major case team.
So during the trial yesterday, your name came up as being involved in a proffer interview with Marquise Welch on January 26th of 2023. Do you recall that interview?
I do.
Were you present for that interview?
Yes.
Were you present the entire time?
Yes.
Who else was present with you?
Detective Wolf and Marquise Welch and Marquise's attorney. I don't recall her name.
And was that Therese Valletta?
That sounds right.
And was that interview conducted at the police department?
Yes.
How would you describe Marquise Welch's demeanor during that interview?
He was quiet, didn't seem happy to be there, maybe a little reluctant to provide information.
And how would you describe his willingness to speak with you?
He seemed to be maybe a little, like I said, reluctant to provide all the information he was aware of, that we believed he was aware of.
And when you say what you believe he was aware of, is that based on other evidence that you had in the case?
Yeah, so we were aware that he drove to the scene of the homicide. We had his phone records and we had his cell phone downloaded. And what he had told us is that his phone had died or lost power, when we knew that was not true, because based on the cell phone download, the cell phone actually captures whether the phone's powered on and powered off, and it was powered off.
And so you had all that information going into that interview with Marquise Welch?
Yes.
And as part of the major case team, have you interviewed witnesses before who may not want to cooperate with police?
For sure, yes.
Can you please describe that?
Well, I mean, you think back in school, people don't want to be labeled tattletales, and in general, really don't want to get involved in crimes that they may witness, may be reluctant to provide information, which is easily overcome when we talk to people and explain the severity of the crime, the victims involved. You know, the average person will, you know, I get it now, and give a full statement. However, there are other people that have strongly held personal beliefs that they shouldn't talk to the police at all about anything, because it could, you know, not only potentially bring physical harm up into including death for talking to the police.
And based on your experience over 20 years as a police officer, you know, what is that type of person labeled as?
The common term is a snitch.
Is it rather common in your experience as part of the major case team to have witnesses who may not want to cooperate or talk with the police?
Yes.
And so then how do you deal with that? Are there certain ways that you deal with those types of witnesses?
Well, I mean, certainly you try to establish some rapport. You try to determine what kind of barriers are in the way here. Are they worried about their reputation? Are they worried about being labeled a snitch? Are they worried about they themselves are going to get in trouble for telling them what they know? And just try to overcome that and talk them through it. And sometimes it can be like pulling teeth.
And so is it fair to say that in that type of interview, you sometimes, you know, have to apply some pressure during that interview?
Sure.
But in this case, as it relates to Marquise Welch, did you apply some pressure?
Well, we just kept going over the fact that we did not believe that he went there without a clue with what was going on. And that just because of the fact that look, you drive by the house multiple times. You park some distance away from the house. It's wintertime. I mean, well, why would you do that? And then additionally, magically in this time frame, your phone shuts off. And he had already told us that he was aware that, yeah, police use phones to track where people are and all of that stuff. So he knew that.
And so you were confronting him on that?
Yes.
But did you ever suggest that he say a particular thing to you during that interview?
No, in fact, I told him, I'm like, look, I don't want to put words in your mouth. I just want the truth and everything that you know about this.
And ultimately, did he provide you some additional details?
Yes.
And did you ever suggest the language of "I shot that bitch"?
No.
Where did that language come from?
From him, and in fact, I was kind of surprised when he said it and phrased it that way.
And so those words came from Marquise Welch?
Yes.
Not from you?
No.
During that proffer interview, did you hear anyone threaten him?
No.
Did you threaten him?
No.
Were any promises made to Marquise Welch that all of his charges would be dismissed?
No, in fact, I don't even know if at the time I was aware of all of his charges in detail or the penalties he was facing or all the details of what was involved in the proffer.
And so that promise was not made to him to dismiss all of his charges?
No, not that I'm aware of.
And did you hear anyone make that promise?
No.
Were any promises made by you that he wouldn't be charged with perjury, even if he changed his statement?
No.
Did you hear anyone make that promise?
No.
Thank you, Detective Bayless. Those are all the questions I have.
Mr. Kirkhoff?
There was a discussion though about he could be going, or Ollie would be going to prison based upon his current charges, right?
I did not have any discussion with him
You
about
didn't?
going to prison.
You don't remember any discussion about prison and his charges?
No, like I said, I don't recall being up to speed on all the charges he was facing or the penalty that he was facing or his guidelines or anything like that.
But about 10 times, as I counted it, you said, we don't believe you, you gotta be telling us more, right? Remember saying that time and time again with him?
I do recall saying that I did not think he was telling us the whole truth.
And basically, how long do you think this total conversation took?
About an hour, a little over an hour.
So you were sweating him for an hour, is that about right?
Sweating him?
Yeah.
No, I mean, we talked to him for about an hour. There were times when we took breaks so that he could talk to his attorney. We weren't in there the whole time, pounding our fists on the table or anything like that.
Until you got what you wanted out of him, right?
Well, I don't know as I got what I wanted out of him or what I believe he knew.
I had no further questions.
Just so I'm clear, Detective, Ms. Prevett brought up promises about prosecutions and things like that, and what charges would be brought or not brought. You have no authority to make any promises like that to him, do you?
I do not, no.
That's the prosecutor's office, correct?
That's correct. They're the ultimate decider in whether or not charges are filed or
And at
whatever.
best, you can make recommendations, but not promises.
That's correct.
All right, thank you. Ms. Prevett, anything else?
No, Your Honor, thank you.
Anything else for this witness?
No,
You're excused, Detective Bayless. Thank you.
Thank you.
Next witness, please.
Thomas Heickel, Your Honor.
Good morning, sir. Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Very good. Please. Go ahead, Mr. Faber.
Good morning, sir.
Morning.
Could you state and spell your first and last name, please?
It's Thomas Heikla, Thomas, Heikla, Heikila.
Back in 2022, what was your occupation?
I was a detective with the Grand Rapids Police Department.
And are you currently retired from police work?
Yes,
Were you assigned in any way to the investigation of the homicide involving the victim Mya Kelly back in December 26, 2022?
yes, I was.
How long were you a police officer?
25 years.
How long in that time were you a member of the Detective Bureau?
I was for the last 13 years of my career.
During the time in the Detective Bureau, did you develop a specialty in terms of criminal investigations?
I did. Starting in 2016, I became attached to what's called our Criminal Intelligence and Technical Investigations team. We were responsible for downloading and analyzing cell phones that may contain evidence, and we also analyze cell phone records that we'd obtain from providers like AT&T, Verizon, T-Mobile, and then analyzing records provided to us from social media, Facebook, Instagram, Snapchat, and we assist detectives in writing search warrants to obtain those records.
How does the obtaining of that information, cell phone records, social media, how does that aid law enforcement in criminal investigations?
It's extremely important. My last, since 2016, I had been involved in cell phones, and there was almost all of our violent cases, homicides, robberies, had some kind of cell phone that was involved in it, whether it being the device itself or ordering cell phone records that might be attached to it. You know, it could be a victim, a witness, or a suspect.
And you testified that you use the records that like AT&T or Sprint or Mobile keep in the ordinary course of their business,
Correct.
and those records are using cell phone technology that's decades old now.
That's correct.
And the records are necessarily accurate for these businesses to provide the best service to their customers.
That's correct.
Can you outline the training and education and experience that you have received in order to successfully perform that job?
Sure, I've attended numerous trainings put on by companies like Celebrate, which is involved the software we would use to download cell phones, Penlink, which was an analytics tool that we use for the analysis of the records, and then also trainings that were put on by the U.S. Department of Justice, which involved kind of both facets of it. I also completed trainings and coursework through a company called ZX, which is now LexisNexis Risk Solutions, and became recognized as a call detail record and geolocation analysis expert, and that was in November of 2018.
What's geolocation analysis?
So geolocation analysis is the analysis of past and present geolocations and the chronologization of those locations for data that's provided on a specific user.
How many hours of training have you received in digital and mobile forensics?
Probably thousands of hours, close to.
Have you ever testified as an expert in the areas of call detail records provided by phone service providers and geolocation analysis?
Yes, I have.
In what courts?
I've testified in this court, in Kent County, and also Berry County.
And in any of the times that you testified as an expert, when your testimony was offered to the court to be recognized as an expert in this field, have you ever not been recognized as an expert in this field?
No.
At the preliminary examination in this case, was there a motion to have you recognized as an expert in service and location analysis and call detail record analysis?
Yes.
And were you recognized as an expert in that hearing?
Yes.
All right, move for the admission of Mr. Heichel's testimony as expert testimony in the fields of call detail record analysis and geolocation analysis.
Any objection?
No.
He is so qualified. Go ahead.
So can you outline to the jury how you became involved in this case and what you did, sir?
So obviously I became involved in this case because it's a homicide, and that's most investigations. We get an analyst that's attached to it and support the detectives if they get a cell phone that they believe might be involved, either left behind by a witness, suspect, or victim. And then if they were to ever develop a suspect in the case, or multiple suspects, they would come to us and request that we try to identify maybe a cell phone number that would belong to the person so that we could seek a legal process. It should be a search warrant to obtain records from a provider that we identified the phone number to belong to, or we would download a cell phone that maybe was obtained from an individual that we believe was involved in the incident.
Were there any particular phones that were the subject of the bulk of your investigation?
Yes, there was. There was two phones, two phone numbers, one identified to a Marquise Welch, where we obtained records, and we also obtained a download of his device, and then a phone number that we identified as belonging to Mr. Newbern, and we obtained records from a provider for his records as well.
Your Honor, may the record reflect defense counsel has been provided proposed exhibits 61 and 62, the phone records for December 26, 2022 for Mr. Welch and Mr. Newbern.
And you want to move those for admission to evidence?
For their
Okay. Any objection to 61 and 62?
No.
All right, thank you. 61 and 62 are admitted.
And in relation to those two phone numbers, did you analyze them for use on the day of the homicide and geolocation analysis?
Yes, I did.
And in preparation for court, did you prepare a demonstrative aid, a video, for lack of a better term, to make this technical information understandable?
Yes, I did.
And again, may the record reflect defense counsel has previously been provided proposed exhibit number 60, that presentation, or move for its admission.
Any objection to 60?
No.
Thank you. 60 is admitted.
Once we cue this up, it'll be projected onto the wall.
Okay.
And Mr. Heckler, it's strange calling you Mr. Heckler. So
It's all right. You get used to it.
how's your golf game?
Very good.
At any point during, I think it's a 15 or 16 minute presentation, if memory. At any point during that, if there's a particular area that you'd like to highlight or to discuss, just indicate to me and we'll pause the presentation.
Okay.
And could we dim the lights, please? All right, you can pause it right here.
Yeah, so I guess I'll explain kind of what I do. So part of what we use is Google Earth to be able to map cell phone records with the Trax is the cell phone mapping software that we use. And we would load that into Trax, and then they produce a KMZ file that we can then open in Google Earth. And it allows the records to show, you'll see cell site markers, you'll see some lines coming off with some marks, and then you'll see some large kind of balloon-shaped things, which are called the horizontal plane. And that's when a call takes place, when somebody makes a call on their cell phone. That's where Trax imposes that shape on the screen, and that would be the estimated distance that they believe the device to be in at the time a call took place. I also add into this video that I create some of the evidence that's been obtained on the case, video surveillance, maybe some financial records, and I'll bring all that together in a timeline to help to corroborate the phone records to show where we're putting a device at a specific time.
One quick question before we resume. The described, how precise is the location of the cell phone based on degree, or to what precision can you place a cell phone?
It would, when you see the horizontal plane and that balloon, the device could be anywhere inside of that or slightly outside of. I believe ZX or Trax has like a 94 to 96% accuracy rate, 4 to 6% error rate. Without any corroborating information, it's tough. I couldn't specifically say a device is at this location, but we're also able to get what's called TDOA data from the network providers, and that's time distance on arrival. So what it gives you is it gives you the cell site, it gives you the sector that the device is off, and it's going to give you an arc, which is an estimated distance. And part of that is because everybody wants to have the best network. Your phone right now is probably identified your primary tower sitting here, secondary tower. That way, if a cell phone call comes in, they route it through the correct tower and you don't miss a call. That's what everybody wants. Because, there's millions of people, they only hold these records and keep them for a finite time period. At the time of this case, T-Mobile was holding the records for 120 days. In May of 2023, they dropped that down to 30 days. So if you don't get on this data, immediately or quickly, you lose it. And this is the data that we really want in law enforcement. Verizon has the same type of data. They only hold it for 8 days. So we'll see those records in here, and then we'll see a couple calls that take place.
And are there occasions when you described two towers? If there's two arcs that intersect, what does that tell you as an investigator?
So you'll see some of the arcs. So if we just had the device that's connected to one tower and its estimated distance away, it's going to leave an arc. My testimony would be that the device would be somewhere along that arc. In this case, we have a point in time where the device is at a location and it's competing between two towers in about a 35-second time frame. So we end up at a point in time where we have one arc and then we have another arc off a completely different tower, and they end up crossing. And that's what we look for in geolocation analysis with these records, because then that gives us a good idea of where we believe that device is at that time period, that 35-second window.
So how precise at the point where they cross? How precise would the data be in terms of where?
Well, you'll see where they cross based on the investigation, and it's pretty precise. I'd say within 30 to 50 meters. I'd say the device is probably right around.
Let's continue, and then just there's no sound for this exhibit number 60. So
No.
Feel free to testify as things are occurring.
So we have the placard identified as 47 Canton, which is the location of this incident. This arrow here indicating the door for 47 Canton that was involved in the incident. 23 Canton's a location where they obtained video surveillance. It's from the address facing south, looking at Canton Street. The time up there in the corner is off. I believe it's not correct. This is the first look of the vehicle that we have involved driving eastbound on Canton, going to be heading out towards Division. So another clip here a few minutes later. Another picture of the vehicle that was identified as being involved in this incident. Again, eastbound on Canton towards Division. We're going to see here is a picture of a person running eastbound on the north sidewalk of Canton, heading east out towards Division. This video from 1135 South Division, which is Luna. I believe that's like a mechanic shop. The video's from outside and it's pointing in a northeast direction. This vehicle involved in this incident's backing into the lot that's at the southwest corner of Canton and Division. I believe the time on this is correct. It says 9:50 up there at the top on the 26th of December, 2022. We see here is an individual running to this vehicle. He's wearing a jacket that's dark on the top, light colored on the bottom. Runs over and gets into the passenger side of this vehicle. The vehicle then goes eastbound Canton and then immediately turns right, which is southbound on Division Avenue. The lights are off. This arrow here highlights the damage that's on the front passenger door of the vehicle. One Hall Street Southwest is a gas station that's located on the northwest corner of Hall and Division. You see the vehicle right here at the top. It's coming southbound on Division, no lights on. It's going to proceed to Hall Street and make a right, which is westbound. It's another picture from the gas station facing south to Hall. So you see the vehicle making the turn here. Time at 9:51 p.m. on the 26th. I believe that's pretty accurate. So if you want to put, based on the investigation after the incident happened, that's pretty much all the investigators had. So they developed stopped this vehicle about 24 hours later on the 27th. And this was a damage that was located on this vehicle. These pictures were taken by our crime scene techs, and Mr. Marquise Welch was the driver of this vehicle. So a cell phone was obtained from Mr. Welch. It was a Samsung. in the contacts, he had a phone number with the last four, a 6753, that was labeled as Tayman. If you want to pause it here, I can just kind of explain what we're seeing. These are some of the text messages that were obtained from Mr. Welch's cell phone. And in green here, this is a text message that he sent. Now we're kind of going back in time now, so we're back to 4 o'clock, 4:34 p.m. on the 26th. So before the homicide happens, we find these text messages in his phone that he sends to Tayman, and he says, "Yo." Mr. Welch sends him about to be outside at, again, 4:34 p.m. The response that we get from Tayman, who I identified as Mr. Newbern, is pull up to Big Top. Or he responds, or I'll be there in a minute, I'm gonna check out now. Mr. Welch responds at 4:36 p.m., I'm here. Mr. Newbern responds, okay. So if you want to pause it, so at this point in the investigation, now we've identified 2 phone numbers, we've obtained a download of a cell phone, so we then obtained search warrants and got records for Mr. Newbern's device, which was on the T-Mobile network, and Mr. Welch's device that was on the T-Mobile network. So when you see anything in blue, that's going to be Mr. Newbern's device. Anything in green would be Mr. Welch's device. So these are TDOA records that I talked to you about and explained. If you want to pause it, so if we were just, have the blue here, as Mr. Newbern, I would say his device is along that arc somewhere, could be slightly off it. Like I said before, we always look to corroborate the records with other information, video surveillance, witness statements. Financial records are great, so that's what we do in this case.
At what time is this?
This, I believe, is going to be right around between 4:26 and maybe 4:30, a little bit after, on the 26th, so 5 hours plus before the homicide.
And you referenced Big Top. Is that close in area to where those arcs are?
Right. Big Top's a grocery store. I believe it's down in Wyoming. So as we play, we'll kind of get a picture of that. Yeah, so these are their TDOA records between 4:26 and 4:35 p.m. on the 26th. That's the location of the Big Top. One of the detectives involved in the case responded down there and got the video surveillance that they had inside and out. So, from the phone, Mr. Newbern indicated he was at the Big Top. We get the TDOA records. They seem to corroborate the statement that we have from the device. Mr. Welch's phone, he indicates that he was there. This is the outside video from the Big Top, and that's the first picture we have of the vehicle pulling into the lot there. The time is, I believe it's 4:33. I believe that's off by maybe a couple minutes. Vehicle's pulling in right here. It's going to sit back in there and park. this is a person that we later identified as Mr. Newbern, leaving, again, wearing a jacket that's dark colored on the top and light on the bottom. Exits from the big top, walks to the vehicle, and then the vehicle's going to proceed to leave out this direction. This video surveillance pictures obtained from inside of Big Top. So if you want to pause it here, this is
I have to take Michael 1 second. Your Honor, may Mr. Kirkhoff and I have a brief sidebar?
Sure. Mr. Eichelman, I need to have a sidebar with you and counsel, just to be really brief.
okay.
Come on over this way. Okay, let's soldier on. Go ahead. I don't know if you have another question at this point, Mr. Faber. Why don't you ask a question, then we'll keep going.
Mr. Heckel, you were about to make reference to what we're seeing right here, so we'll pause it still.
Right. Like I said before, we look for financial records to help corroborate, our cell records and other evidence on the case. And this was a financial record that we obtained that we identified as belonging to Mr. Newbern. And it's for a purchase at Big Top Market, the address on Clyde Park Southwest, the date on the 26th of 2022. 1638 is the time, and it's for $20.24. Now what we're gonna see is some of the movements of the device for the rest of the day on the 26th, up until the homicide happens. So what you'll see is the devices are pretty much moving together based on the mapping. This is from 4:26 to 5:35 p.m. From 5:26 to 6:35 p.m. on the 26th. From 6:26 to 7:35 p.m. And then 7:26 to 8:35 p.m. up until 9:35 p.m. where they end up on the northeast side of the city. And again, that large handoff areas there are phone calls that are taking place on the devices.
If you pause it there.
And this is an outgoing voice call that Mr. Newbern's device makes, and he calls the 9651 number. It's at 9:34 on the 26th, and that number's to Marquise Welch. It's an 18-second call, so at the time of this, the device could be located anywhere inside of this handoff area or slightly outside of.
755 College within that blue bubble.
Yes, it would be.
And then the time, 21:34, again, civilian time as well.
9:34 p.m.
Okay.
And this is how that phone call looks on Mr. Welch's record, same time. He's actually connected to the same tower. And again, I'd estimate the device to be inside of that overlay or slightly outside of it.
Is there a McDonald's within that green bubble?
A McDonald's?
Yes.
Yes. Probably a couple of them. Now this is after 9:35 p.m. The devices start to move to the south and east from the northeast side. And these are going to be the TDOA records for Mr. Newbern's device, and it's from 9:47 and 15 seconds to 9:47 and 50. So if you want to pause it there for a second, if you did already. So at 9:47 and 15, the device connected to this tower off this sector, which is the line, and the network estimated it to be 0.39 miles away. So it's that inside arc here. It estimates the device to be away from it. The next record we're going to see is it's still connected to this tower. It's going to be 5 seconds later, and now the device is moved out to 0.44 miles away. If you want to pause it there, now we got a point in time now where we've added a second tower after this first two connections. So we have the device is at a point where it's, we got two towers competing for the best serving site for it, but it's seconds apart. So now it's connected to this tower under this sector, and it estimates it's 0.68 miles away. And that's 39 seconds. So now within 24 seconds, we've had the device make 3 or 4 connections to 2 different towers. And that's where we start to see this crossing. And that's what we look for. And 47 Canton is right there.
At what time?
Well, at 21:47 and 39 seconds, and then you will get a couple more hits where it's along this, so within that 35-second period, that's where we're getting those locations. So another connection, now it's on this tower at 45 seconds, and then 5 seconds later still connected to this tower in this sector. And then the placard there marks 47 cans, so I'd estimate the device to be somewhere in that circle there. Probably wondering why Mr. Welch's device doesn't show up. If you want to pause it there, I can kind of explain. So between 9:44 and 10:04, we don't see any activity where his phone's connected to a tower. And that's something I relayed to the detectives in the case to have them maybe further question him about, because the phone was either off or it was in airplane mode. So these are the raw records that we received from T-Mobile showing that TDOA data. And the last location we had for him, the last time was it says 2:43, but they provide them in UTC time, so you got to go back 5 hours. You know, so between 9:44 and 10:04 p.m., we don't have any locations for Mr. Welch. And this is now between 10:05 and 10:31 hours. Device moves south here, and we'll start to see Mr. Welch's device then show back up. And this is where the device has ended up in this area after the homicide.
Is that back near Wyoming area?
Correct. I believe it's down in that general area.
Thank you, Mr. Eichler. No further questions.
I just have a couple questions that might help the jury understand a couple things. So if you're in a very rural area, such as, like, if you're in the cornfields of Iowa, there's not much around. There's only like one cell tower that your phone will probably ping off if you make a call, correct?
Correct.
Okay, but if you're in a highly populated or dense area, such as the city of Grand Rapids, that's where you're dealing with potentially multiple cell towers.
Right.
Okay.
Yeah, I mean, you know, in the downtown area here, you know, with 5G, there's, you know, there are probably hundreds of towers right down here because they got to support all the people that are down here making calls. Whereas if you get out, you know, out in say Arizona, you're driving across New Mexico, you might be on one tower for, you know, 8, 9, 10, maybe 15 miles.
Okay.
That's just it's the
Okay.
nature.
We
the
saw,
technology.
so when you download a phone, you can also get text. We saw those, right?
Correct. Text messages are something we get off phones, pictures, videos, call logs. That's all stuff we would look at. And again, when I download a device at the time of this investigation, I was a one-man show. We used to be two-man, but that guy left, and they weren't going to hire anybody else. So I would download the device and provide the detective with the data in a readable format back to them to go ahead and go through, because they know the investigation better than anybody else. So then if they found something of importance, they would come back to me if they wanted additional information, like, you know, the phone number that we identified as Tayman. They would say, hey, let's get the records for this individual.
Okay. Hey, can you download voicemail?
Sometimes if you have a voicemail that was saved on a device, sometimes you could get it, but a voicemail wouldn't come from a carrier. T-Mobile's not going to provide you voicemails. They're not going to provide you with text message content either. I mean, the TDOA records, they only save for a certain amount of time. Could you imagine if they tried to save every text message you sent? I mean, you'd be paying a lot more for cell phone service.
And of course, there's no way to retrieve an actual conversation.
No,
All right, thank you. I thought that might help the jury.
not without a wire.
All right, very good. Ms. Kirkhoff, any questions for Mr. Heikola?
Exhibit 61 is Mr. Newbern's cell phone records that you obtained, correct?
Correct.
And that is how you put this together, correct?
Correct.
Could we go to exhibit 60, go to 12 minutes?
Pardon me? A big green, yeah, that's the horizontal plane is what that's showing.
Okay.
Yep,
And that is the data from the cell phone towers, correct?
well, what that is that's an estimated distance. So what we would get from the tower, what they would give us for the records, they'd give us what tower the phone call was connected to, what sector it connected to, and then this estimated distance is something that the cell site mapping software we use uses an algorithm based on cell site density and drive
The
scans.
cell phone could be anywhere within that area.
Correct. Could be within that area or slightly outside of it,
All right.
yes. Yep.
How wide is that area?
That tower, from my experience of dealing with numerous calls in the city of Grand Rapids, covers a large area.
So it is not a precise GPS.
Oh, no, not the call records aren't, no.
All right. Play it. Okay, stop, please. Now, this is from the cell phone data that you received. It shows a call at 9:34:17, correct?
Correct.
And that is from Mr. Newbern's phone, and it's also showed up on Mr. Welch's phone as a receiving call at the same time, correct?
Correct.
So we can be pretty sure that call was made from Mr. Newbern's phone to Mr. Welch's phone.
Correct.
Okay. Which means at 9:34:17, Mr. Newbern's calling Mr. Welch on the cell phone, correct?
Correct.
Means they're not together, correct?
That's
More than likely.
more than likely they're not within eyesight of each other.
And this call is directly on Exhibit 61, correct? The middle of the second page. At 21:34:17 outgoing, correct?
Correct.
Okay. All right, can you play it again? And that just shows that call was incoming to Mr. Welch's phone at the same time, correct?
That's correct. This is how it showed up on his records, yep.
Stop, please. Now, this shows a call on Mr. Newbern's cell phone, right?
No, this isn't a call. This is network engineering data that's maintained by the providers that I explained before. There's no activity that's taken place on the device other than the device is just on.
Okay, because there's no call on this record for that, is there?
No, there isn't.
So where are you getting this information?
This information's provided from T-Mobile. It's time distance on arrival, like I explained. It's the network engineering data that they maintain to help provide the best coverage on their network. The other part that this plays in is cell phone carriers are required to have enhanced 911 so that they're able to, when somebody calls 911, provide a good location for people to find them.
And that cell phone could be anywhere within those arcs, correct?
If I had one arc, if we had one arc, say it was, all we had was this one cell tower and we had one arc, I'd estimate the device to be somewhere along that arc or slightly off of it. But since we have the data provided by them, in a 35-second window. We have actually 6 connections that involve 2 different towers in 35 seconds, and where they cross is, you know, I put where 47 Canton is, and then I'd estimate the device to be somewhere in that radius of that circle.
But that's just your estimate, correct?
It's a pretty good estimate.
But it's not a GPS, is it?
No, it wouldn't be a GPS. No, the only locations that we're using are location of this tower and then the estimated distance they provide.
And these cell phone towers, if one of them is overloaded, then it will bounce to the second tower, correct?
If it's a call that they're making, but if you try to make a call, yeah, it could bounce to another tower, which is kind of what we had here, where we have an area where the device is at, and we got 2 towers competing with each other on who's going to be the best tower.
Correct. If one is overloaded, it will go to the second.
Well, it's not necessarily overloaded. It's one that's identified as having a better signal than the other. Overloaded could play a role in it, but
Okay, so it's possible to have more than one cell tower in play here, and it may not even be the closest cell tower, is it?
well, yeah, that's possible.
I have no further questions.
Anything else, Mr. Faber?
Yes, briefly, Mayor. So, Mr. Heickel, if I understand your testimony correctly, the last call or use of the device, Mr. Newbern's device, before the time of the murder at around 9:50, would have been the call to Mr. Welch at 9:34, 9:35?
Correct.
Nothing further.
Anything else, Mr. Kirkhoff? Okay, you're excused. Thank you, sir.
Thank you.
All right, any more witnesses or evidence from the prosecution?
No additional witnesses, Your Honor. If I could just confirm that all of our exhibits have been admitted, with
Well-
the exception of 63.
Okay, yeah, 63 was not admitted. I think there might be one other one that was not, and I believe it's 23. Mr. Welch's phone, Officer Smith, I'm not sure that was admitted. It may have been. We're getting a note from my clerk as well.
We would move for its admission at this time, Your Honor.
Any objection?
Which one?
It's 23, Mr. Welch's phone.
No.
All right, very good. 23 is admitted.
Thank you, Your Honor. Then with the admission of all of those people's exhibits, the people rest.
Okay, the prosecution has concluded its case. This would be an appropriate time to take a break. We'll shoot for 15 minutes, but my clerk might update you on that, depending on what happens when I talk to counsel here in a few minutes. So I'll rise to take some jury. We'll shoot for 10:15, but it may be later. We'll let you know, okay? Thank you. All right, be seated, please. Okay, any motions you'd like to make before the court, Mr. Kirkhoff? Okay. Then I will instruct Mr. Newbern again. Mr. Newbern, I told you this yesterday, but I'm going to tell you again, okay? You have the absolute right to testify and not to testify. Do you understand that?
his name Teddy? I'm gonna assume it's Teddy, right?
Teddy or Theodore?
Teddy's iPhone?
Teddy works. I call him Theodore.
I'm gonna try to lock it on him.
I don't need that in my mouth.
Guess I like that better. Can you hear me okay?
I can. I'm just working on my video here. Sorry about
Sure.
that.
Theodore, the officer.
Oh, okay. Then yes, he was.
Was already testified, right?
Now I got two of them. Where's that car? Well. Not this one. Yeah. All right, can you hear us okay?
Yeah, I can hear you just fine.
Are we ready then? Bonnie, are you ready? Yes. Yeah, I'll switch up to already. All right, please. Towards back to me.
All right, be seated, please. Before we bring the jury back in, I wanted to talk to everyone about schedule. This was my thought, so I'm not going to decide this unilaterally without counsel's input, is that this testimony is not supposed to take real long, and then the witness will be, or the evidence will be concluded. What I was thinking is we'd take a long break, relatively speaking, from about 10:30 to noon, where we talk about final instructions, and the final arguments could be prepared by, or closing arguments could be prepared by counsel, and then we'd have the jury get lunch and then start up about noon. Does that work for you, Ms. Prevett?
Yes, Your Honor.
Mr. Kirkhoff?
Start up when?
At noon. Like get an early lunch starting at noon.
Okay.
Okay?
Yeah.
All right, that's what we'll do. All rise for the jury, please. be seated, please. All right, Mr. Kirchhoff's going to call a witness. It's going to be by Zoom. Everyone's agreed to that procedure, and so we'll proceed with that at this time. Good morning, sir. Can you hear me okay?
Yes, Your Honor.
All right, can you please, yeah, you're good. Can you please raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Very good. Go ahead, Mr. Kirchhoff.
For the record, your officer Theodore Van Vliet, correct?
That's correct, sir.
And you testified earlier in this case also, correct?
Yes, sir.
Okay. Now, you were one of the first officers on scene at 47 Canton back on December 26, 2022, correct?
Yes, sir.
And you did, excuse me, you did talk to Omar Dana at that time, correct?
Yes, sir.
And he told you that Mya opened the front door and had an argument with whoever was outside. Is that correct?
Correct, sir.
And that that person had a weird voice and sounded like a white male. Correct?
Yeah, correct. Yes, sir.
He did tell you those things.
Yes, sir.
No further questions, Your Honor.
Anything for this witness, Ms. Brevet?
Yes, Your Honor, thank you. Good morning again, officer.
Good morning.
And are you certain that he told you that Mya opened the door?
Correct. So you opened the door, you had an argument with somebody outside.
And so, but anything that Omar Dana said was captured on your body worn camera, is that correct?
Correct. For that preliminary discussion I had with him.
And did you have any other discussions with him that were not recorded on your body worn camera?
That's my recollection, no.
So anything that he would have said, we have it on body cam, correct?
Yes. Correct.
Thank you. I have no other questions.
Mr. Kirchhoff, any other questions?
No, Your Honor.
All right, thank you, Officer Van Vliet. I think you were finally done with you. You're excused. All right,
All right.
we're all set. Have a good day.
You too.
All right, Mr. Kirchhoff, any other witnesses or evidence?
No, Your Honor.
Any rebuttal evidence?
No, Your Honor.
All right, thank you. All right, let me instruct the jury what's going on now. Okay, so the evidence has concluded. To get the trial done and get you deliberating, we need to have what are called closing arguments and final jury instructions. It's going to take a little bit of time to put that together. So what we're going to do, I know it's really early, it's about 10:23, but we're going to take a break till noon. And also, this is your very early lunch break. So if you want to get something to eat between now and noon for lunch, that would be the time to do it. Because at noon, we're going to start up again and hear those closing arguments and get the final instructions so we can get you deliberating this afternoon, all right? So we'll see you guys at noon. All rise for the exit of the jury, please. All right, be seated, please. Okay, counsel, let's go back into my office and look at the final jury instructions, and then we'll give you time to do what you need to do, prepare your final arguments, or closing arguments. Anything else before we go off the record, Mr. Faber?
No, thank you.
Anything else? Okay, very good. I'll see you guys right now, back in my office, please.
No, I don't need to talk. All right. Just get him something, you guys.
Go to you, shall we be back?
Okay. Who's gonna be able to find the closing? You don't have to.
right, be seated, please. All right, before we bring the jury back out, I just want to confirm there's no objection to the final jury instructions and the jury verdict form. Is that a true statement, Ms. Prevet?
Yes, Your Honor.
Mr. Kirkhoff?
Yes.
All right. Anything before we bring the jury back out, Ms. Prevet?
No, Your Honor.
Mr. Kirkhoff?
No.
All right, very good, thank you. All rise for the jury, please. All right, be seated, please. All right, ladies and gentlemen, what we're going to do at this point are what we're going to call closing arguments. Ms. Prevet will go first. She's the prosecutor. Then Mr. Kirkhoff will make a closing argument. Then Ms. Prevet will make, if she wants to, what's called a rebuttal argument to counter what Mr. Kirkhoff says because she has the burden of proof. I will then give you some instructions on the law you are to follow in this matter and during deliberations, and then we'll get you deliberating. Okay? Go ahead, Ms. Prevet.
Thank you, Your Honor.
Good afternoon. Thank you again for your just time and attention during the course of this trial. I know you have been very attentive and also very timely, as Judge Quist has referenced before too. So thank you for that. I know it's been a long week, but of course it's a very important case to both sides. And so now that you've been here all week, you know why we're here. We are here for what happened to Mya Kelly back on December 26th of 2022 when she was at her home at 47 Canton here in the city of Grand Rapids. She started off that evening with her boyfriend, Omar Dana, and her 2 young kids, simply going to watch a movie. But then she went to open this door, and her life ended. And she ended up like this. So when such a tragic and senseless murder happens, we have to ask how and why, right? How did this happen? We know from the evidence here that this was an intentional and premeditated act of the defendant. The defendant shot her in the head in front of her 2 young kids who were in that very room. One was right by her and one was a little further away, but it was happening right in front of their young eyes. We know how it happened. So why did it happen? And I submit to you there's no good reason or acceptable reason as to why this happened, right? It's not something we have to prove either, but something you will likely consider during the course of your deliberations. We don't have to prove motive. We don't have to prove the why. We only have to show that the defendant committed this crime, and that's what the overwhelming evidence in this case shows. But I submit to you that if we at least didn't try to figure out the why or to determine the motive, you would likely question us, right? Or the police investigation. So again, there's no acceptable reason whatsoever as to why this happened. But we at least tried to figure it out. You heard during the course of this trial, that in that neighborhood, snitching is a big deal. You heard that term from Detective Bayless, who told you what a snitch is, and that people don't always want to cooperate with the police. Why? Because snitching can be life or death. People don't always want to cooperate with the police. So consider the danger that some witnesses perceived or felt that they were in if it looked like they were cooperating with the police or testifying or giving statements. There was a perceived danger to many witnesses in this case. And snitching may be what led to the death of Mya Kelly. No wonder why certain witnesses are reluctant to cooperate or testify in cases like this. I mean, you heard from a number of them, including Marquise Welch, Caitlin Hines, and Jasper Keys. These witnesses were not eager to testify in this case. They were somewhat reluctant, for good reason in their mind, their perceived danger, if it were shown or it looked like they were cooperating with a police investigation. So you may not know exactly why this happened, but there were some possibilities for why this happened, right? You heard a number of times the name Terrell Franklin, Marquise Welch, and of course Keyante, the defendant. I mean, these three men in this somewhat inner circle, they were entwined. They all knew each other, they were friends, they hung out with each other. And what's something that they all had in common? They were not on good terms with Omar Dana on the date of this murder, on December 26th of 2022. So what do we know about Terrell Franklin? Well, we know that he was mad at Omar Dana. We know that he was mad at Omar Dana about what happened on December 19th, right? When Terrell Franklin was arrested from 47 Canton, and he thought that Omar or Mya had snitched on him, had got him in trouble in some way, had cooperated with the police, that they had snitched. So Terrell was still mad at Omar on the date of this murder. On December 19th, Terrell Franklin went to jail. He was arrested from 47 Canton. We know through the evidence that the defendant was friends with Terrell Franklin and that he was with Terrell Franklin on December 19th. And we didn't get into a lot of details about what happened at the graveyard or the cemetery, but we know from the evidence that Terrell Franklin was with the defendant. We know that Marquise Welch was friends with Terrell Franklin and the defendant. And after December 19th, all three of them essentially are on bad terms with Omar. Terrell Franklin is in jail. The defendant was not. He was out. And Marquise Welch, he had the car, right? He had the car that was able or allowed this to happen. So they were all connected. And they all had problems with Omar Dana. We heard from the defendant that he confirmed that Terrell Franklin had got into it, or his words, with Omar Dana on the phone on December 19th. You heard that through his words in the investigative subpoena.
I'm sure you, one at a time, if you recognize the person, number two. Who's that?
He set up a little organ boys. Like this is Terrell, my cousin. You know what I'm saying? Friend. I know who he is, but man, I ain't seen him in a minute because him and Terrell got into it when we was on the phone. And they were talking about Marshawn, because we was supposed to go on Marshawn Graves site. That's where I really thought this was over, Terrell at the grave site shit. And he was talking to him, trying to ask him like, where's the grave site at so he can piss on it. So like
So in this, the defendant is saying that's what he thought this was all about. The stuff that happened with Terrell at the gravesite. The defendant in this clip here is admitting that he was with Terrell Franklin and that Terrell had got into it with Omar Dana, and he thought it was all about what happened at the gravesite. We know that Terrell Franklin was not on good terms with Omar Dana on December 26th, and the defendant was close, good friends with Terrell Franklin. The defendant goes on to confirm that he was with Terrell Franklin at the cemetery on December 19th.
Anything more about the crime that we're investigating? Maybe I just haven't asked the right question, but do you know anything more about this crime Because we're not going to stop investigating it. It's a murder. Do you know anything more about this crime than what you shared with us today?
No, sir.
You're just completely shocked that you're even here because
I really thought this was the graveyard, because the graveyard shit, because when Earl got, he just talking about he had to kill somebody, so really I'm already thinking I was doing bullshit because I was with him when he did that, but I left, so I didn't know what really happened, so I didn't know.
So here the defendant is saying he was with Terrell Franklin at the gravesite, but the defendant left. And then what does Terrell Franklin do? Well, we know that he goes on later that night to get arrested at 47 Canton. So from that, Terrell Franklin is upset with Omar Dana, and it's reasonable to conclude that the defendant was also upset with him. He was close with Terrell Franklin. They all were in that circle. This group was not on good terms with Omar or Mya on the date that she was killed. And what we know from this case is that regardless of motive, so that that's a possibility as to why this happened and what the motive was. But regardless of the motive, the evidence leads to the shooter in this case. And all the evidence leads to the defendant. We know it wasn't Terrell Franklin, right? Terrell Franklin was in jail. We know it wasn't Marquise Welch because he was the driver of the getaway car. All the evidence leads to this defendant as the shooter. So you heard from a number of witnesses in this case and heard and saw all of the evidence that was presented. And it started with the officers responding to the scene on December 26th for the call of shots fired in that area at 47 Canton. And when they arrive, and that's exactly what they find. They find the neighbors there, right, the Ericas, if you will, both Erica Atkinsons, who lived at 43 next door, and then they find Mya Kelly, where she died, right on the other side of her front door. And you saw that video from Officer Middleton, who was one of the initial officers on scene, show you kind of what the chaotic scene was when he arrived. And that you saw Omar Dana come out of that house, out of 47 Canton, because he had been in there and had been with Mya when she was shot and killed by the defendant. Omar Dana told us that Mya went to answer the door because there was a knock, a somewhat quiet knock, and Mya went to answer the door. He told you that the door was never opened, but she went over towards it. She said something to the effect of, "Who's there? Who is it?" And the voice on the other side responded in a way that was disguising his voice, trying to avoid detection. And Mya looked out the peephole and she did not see anyone outside. So that person, who we now know was the defendant, knocked again. And so Mya Kelly was talking to Omar about, "Oh, someone must be playing. I don't see anyone." She looks out the peephole and doesn't see anyone there. They must be playing. And the evidence in this case shows that she had turned because she shot in the left side of her head. She was talking to Omar when the shots rang out, and Dr. Stark told us that she did not have a chance to survive that type of injury. Dr. Stark also told us that she had the material or the defects on her face consistent with being shot through the door, because all the evidence shows that door was never opened and she was shot through it. Omar Dana, through the course of the investigation, talked to detectives. He talked about problems that he had with people, including the December 19th incident. And he told detectives, specifically Detective Wolf, that the bullet wasn't meant for Mya. It was meant for him. But regardless, in one legal concept that you will be instructed on by the judge is, of course, I think as I mentioned during jury selection, at the end of this trial, you are the experts on the facts, right? The decision is yours. You're the experts on the facts. Judge Quist is the expert on the law, and he will give you the law you are to follow. And I believe he will give you an instruction on transferred intent. So even if the bullet was meant for Omar, the crime is the same when it struck and killed Mya Kelly. The jury instruction reads, if the defendant intended to kill one person, but by mistake or accident killed another person, The crime is the same as if the first person had actually been killed. The crime is the same. Omar Dana told you during his in-court testimony that Mya never opened the door. The door was never opened at any point. His conversation with Officer Van Vliet was captured on body-worn camera. And Omar Dana gave his statement to Officer Van Vliet about what happened. And in that statement, of course, you'll have this to listen to as well. Because Mr. Kirchhoff was asking some questions about, well, didn't you say the door was open? Didn't Mya say, she went over to the door and you said the door was open? Nowhere on this video does Omar Dana say that. He says Mya went to the door. He never says she opened the door. And of course, you can listen to that as well. But in the video, it says she went to the door. He never says that she opened the door. So even though Officer Van Vliet testified to that, the evidence shows that he was mistaken, because this video speaks for itself.
Somebody knocked on the door. Somebody knocked on the door. And they knocked on the door. I went to the door. And she went to the door. She was close to it, so she went to the door. Somebody said something like, so if I'm not mistaken, I probably got something like a higher voice or something like that. I don't know, like they made a funny voice. It's just like somebody playing. And she turned to me and said somebody's playing, and then shot she put on, she fell. I dove over and got my kids. I dove over to the ground with my kids. I ran, I called the police, but I was scared because I heard a lot of rumbling, and I didn't know if it was what it was, but I had my kids, and I was scared, and I was on the phone with the police trying to get them there, and I didn't want nobody to hear me, so I could have on the police, and I got the neighbors, but the neighbors, I was so scared, the neighbors begged me for help. I yelled out the window, who is it? I tried, I did everything I could, bro. I tried, bro. I'm scared, bro.
So, did you go on?
No, nobody saw it through the door. You can see the shots, so I promise you, sir, please, somebody get her some help, please. I quit. Yes.
Remember last week
Yes.
with Mr. Terrell?
Yes, that's my cousin. That's my cousin.
Terrell had anything to do with this?
Huh?
Terrell had anything to do with this?
I don't know. He's in jail to my knowledge. I don't know. I don't know. That's why. Sir, can you please, can we do this, sir? Can we do this? Is there any way possible where I can get like, her parents, my parents are downtown, and you just talk? Please, yes, can we please, sir? I need to calm down. I need some comfort. Yes, those are our kids.
Are they okay with staying with the neighbors? Is this for summer safety?
Tonight? No, I don't know. I don't know. I didn't do it. I don't know. We're both. I'm scared, sir.
Okay.
Please.
Where do their parents live?
They stay in Cedar Springs.
What's her mom?
Angela Arnold. Yes, her father's name is Robert Kelly. Sir, please, I'm so scared right now, sir. Please, can you please give me like some type of security? Like, is there any way I can, sir, please give me somewhere where I can talk to her parents, my mom, everybody, please, sir. I'm scared right now. Arnold. Her father's name is Robert Kelly. Oh my God, I'm losing my mind, bro. I just witnessed my girl get her bro. Please help me, something, sir. Please keep good, bro. I'm scared, bro. I'm scared.
In this video, Omar Dana never said Mya opened the door. And Omar Dana never said there was an argument. The evidence shows that Officer Van Vliet was mistaken about that. The video shows that Omar Dana said Mya went to the door and there were some words exchanged. Not that the door was open and that there was an argument. Listen to it yourselves. So after the officers arrive on scene and speak with Omar Dana and try to save Mya Kelly, the officers continue with their investigation and speak with neighbors on scene, Forensic personnel arrived to process the scene. We hear from the Erica Atkinson, both of them, both Ericas, that they hear approximately 3 to 4 shots. They did not hear any argument or any real discussion, and they did not hear or see anything unusual before the shots were fired. They did not see the shooter. Forensics found a bullet perforation of the front door. Forensics also found 3 9mm Luger casings in the snow. No prints were obtained from those. And officers continued to canvass the area for suspects, evidence, and video. When both of the Atkinsons were testifying, they talked about seeing a dark car driving down the street towards Division after the shots were fired. They didn't know anything more about that car. They thought they saw one person as the driver looking towards the house. They didn't know if they were involved or not. It was just something they noted after the shots were fired. So we can take a look on the video that we have from 23 Canton around that exact time, which shows 2 dark colored cars, which was one of them may have been what the Atkinsons were referring to. But let's look at the timing here. Yes, please, thank you. So we're going to push play now. In about 5 seconds, you're going to see the defendant enter onto the screen running away from the shots. The shots had already happened. So the defendant already ran across the screen. The one black car that already went across the screen, they came into view after the shots were fired. And this other black car that we see, or we'll see in a moment on the right-hand side of the screen, I ask you to look at that. Keeping in mind that the shots had already happened, the defendant has already fled the scene. And now we start to see that there's a dark colored vehicle going towards Division, right? After a lot of time had already passed from the shots and from the defendant when he was fleeing the area. I mean, wouldn't you think if that car was involved in any way, why would it be sticking around? If that car was involved in any way, it would have fled, just like the defendant did. I mean, we can see from this video that it was a normal residential area, right? There's a lot of regular activity happening. We saw earlier in the video on the upper left-hand side of the screen, which is at 20 Canton. There was a truck there with headlights on. You can see in the back of the video that there's cars kind of traveling around the block. This was regular activity was taking place, right? Cars going up and down the street. So if that vehicle was involved, would you expect it to stay there for so long after the shots were fired? No, it would get the heck out of there. That vehicle was not involved. That's not what the evidence shows. But of course, both Ericas mentioned it because it's something they saw. They saw a black vehicle, which we see on this video, but the evidence shows it was not involved. Just have a moment. Stacy, what was that trick you said? Oh, it's back on. So never mind. So you heard from the officers and witnesses on scene that day, on December 26th, right? From Officer Middleton and Van Vliet, who were investigating. Officers canvassed the area, tried to collect video surveillance, but they didn't find any other pieces of evidence or suspects then. But we see what happens on December 27th. On December 27th, there's a break in the case, if you will. That Officer James Smith arrests Marquise Welch in this vehicle the day after the murder. This arrest of Marquise Welch in that vehicle allows investigators to determine the connection between Marquise Welch and the defendant, right? Because at this arrest of Marquise Welch from this vehicle, they're able to seize his phone, right? And by looking into Marquise Welch's phone, they can see the communications that he's having with this defendant on the day of the murder. So at that point, they look into those communications further and realize there's a connection there. So you heard from Detective Derek Hall, who was one of at least 3 detectives assigned to this case. And Detective Derek Hall was tasked with a lot of the video surveillance, either collection or analysis, right? He also analyzed some of the text messages. He was able to get some records related to the transaction at the Big Top store, and he was able to obtain a lot of video surveillance. And thank goodness he did, right? Because a lot of those businesses had a lot of good surveillance video from December 26th, so that the defendant and Marquise Welch couldn't avoid detection, because the officers did a thorough investigation of obtaining that video surveillance, and there was some good video, and it was able to tell them a lot about this case and a lot about what happened. And so what do we know from all the records, the messages, and the video surveillance as it relates to this case? Well, we know that Marquise Welch was communicating with the defendant in the hours before the murder. We know that the defendant and Marquise, they had each other's numbers stored in their phone. Marquise Welch told the defendant, who was identified as K-Man in these records, that he was about to be outside. And through the analysis of these records, the detectives were able to determine that that was at the Big Top store. Marquise Welch tells the defendant about to be outside. He tells him, I'm here around 4:36 p.m. So we know they're with each other earlier in the day, around 4:30. The defendant in his text messages says, I'll be there in a minute. I'm in checkout now. Detectives were able to determine that the number associated with Keyante Newbern was 856-6753. And the defendant later confirmed that phone number, that it belonged to him, and that he absolutely had his phone on him on the day of the murder. He had that phone for approximately 4 years, and he confirmed the number.
Do you have a cell phone?
Yes, sir.
What's your cell phone number, sir?
616-856-6753.
And is that phone in your name?
No, it's not.
Whose name is the phone?
My fiance,
What's her name?
Arfa Sharif.
Okay. And you guys have,
So we know it was the correct phone number. We know it was the defendant's phone number. He admitted to that. We see in some of the video surveillance from the Big Top, you can actually see him on that video surveillance with his phone in his hand texting. And all of that matches up that at that very time, he's texting Marquise Welch, who is about to pick him up outside. We know that from his phone records, and that also matches up with the financial record that we see here from the Big Top market. That the defendant used a card to conduct a transaction in the amount of $20.24 around 4:38 p.m., consistent with all the other evidence in this case. You see in this photograph from the Big Top interior surveillance that the defendant is wearing a very distinctive coat, dark on the top, white on the bottom, and he has a Michigan hat on. He also has a hood up. You saw and heard from the officers involved in the search at 36th Street in the city of Wyoming, which was the apartment of his fiancee. That Michigan hat was found there. No question that the person in the big top photographs and video surveillance was the defendant. We know this is Marquise Welch's car. From the video surveillance, we know that Marquise Welch picked up the defendant in that vehicle at the big top on the day of the murder, just hours before. They were clearly together. That's what the evidence shows. So we know that Marquise Welch and the defendant were together in this vehicle on that date. Earlier in the afternoon at the big top, and we also know that they were together after the shots were fired. Additional video surveillance was found at Luna Auto on Canton. And in this photograph, we see the defendant running away, fleeing the scene after he had just shot Mya Kelly in the head, wearing the same very distinctive coat, black, dark on top, white on the bottom, running towards Marquise Welch's car. Marquise Welch, who we know that was his vehicle. He's admitted to you during court that that was his vehicle. It belonged to his mom. He drove it a lot. Very distinctive vehicle, right? With distinctive damage on the driver's side and also some distinctive damage on the passenger side. So the evidence clearly shows that was Marquise Welch's vehicle. The evidence shows that the defendant got into that vehicle. After Marquise Welch backed into that area, when I said earlier that he was acting as a driving the getaway car, that's what the evidence shows here, right? That he had dropped the defendant off in that area after they canvassed around the block 2 times. He knows exactly where he's going to park. He backs in, he turns his lights off, and waits for the defendant to come back. And that's exactly what the defendant did. He comes back running. He runs back to the car, gets in the vehicle on the passenger side, just like they had planned. Through the investigation, we learned the timing, of what happened back on December 26th. From the video surveillance, we can see that the Dodge Journey was on Canton for the first time at 9:46 p.m. That's the first time they drive around the block, right? To make sure they know the house is there. They're looking what's going on. They're canvassing the area at 9:46. They drive back again, and you saw that the route that they took around the block. Marquise Welch drives the defendant back around, and this time he drops the defendant off, as the defendant requested, in front of 47 Canton. So then as they talked about previously, because they had to have some sort of plan for this, after Marquise Welch drops the defendant off in front of 47 Canton, he goes and parks down the street and waits for him. 9:50, the sound of gunshots on the Sunoco video, which is consistent with the time that Omar Dana told you about. I believe he said 9:49 was the time that he remembers. And we hear the gunshots at 9:50. And then at 9:51, after the defendant had run back to the waiting Dodge Journey, we see the Dodge Journey on video westbound on Hall at 9:51. So they were in and out between 9:46 and 9:51. Where did they go from there? Well, we know from the evidence that from there, they leave and they head back to the 36th Street area, right? That's what the cell data shows, the phone records show that. And we also hear that from Caitlin Hines. You heard from Caitlin Hines during this trial that she knew Marquise Welch. I think she said that she had planned on smoking some weed with him. that she expected Marquise Welch to come to her apartment, but she was surprised, right, and confused when the defendant is also in the car. That he's kind of slouched down, as she demonstrated, in the back seat. She wasn't expecting him. She was expecting Marquise Welch. But it shows that the defendant was still with Marquise Welch after the murder, after they had taken off from that Luna auto. That's where they went, to 36th Street. The defendant was still there. And Caitlin Hines identified the defendant in court. She said, yes, that was him. I didn't really know him before, but yes, I would recognize him, and that's him. I mean, is it really that surprising to you that in the beginning of this investigation, she might not have wanted to get involved? Or that when detectives are showing her pictures and asking, do you know this person, or do you know anything else about this person, that she says no. Caitlin Hines is another example of a witness who was reluctant, not wanting to cooperate with the police. But now she was brought into court and put under oath and asked, would you recognize that person if you saw him again? And she said, yes, it's him. So you also heard from Marquise Welch, of course, during the course of this trial. He told you many things. The majority of things, if you recall and think back to what he admitted to, he told you about things that he really couldn't get away from, that he couldn't deny, right? Things like the text messages, things in black and white that can be shown to him, right? This is your phone, this is you. Yes, it is. He couldn't get away from that. Or the cell phone location data, or the fact that his car was on video, backed in, turning his lights off at Luna. So he couldn't get around that. So of course he's admitting that to you. So I ask you to compare that, when you're deciding at the end of the day who to believe and what to believe, because of course that's your decision, as it is in every case, right? You have to decide as a witness, are they telling the truth, are they lying or mistaken? I ask you to consider all the facts, look at everything. And for any witness, and I believe the judge will instruct you, that you can choose to believe all, none, or any part of what a witness says. So when it comes to Marquise Welch and you're debating, what do I believe? Well, how do I do this? I submit to you and I ask you, believe the parts that match up with all the other evidence in this case, right? He's telling you many things. And the majority of those things are corroborated by other pieces of evidence. Because, of course, any witness can say anything, right? A person can take that stand and say whatever they want. So corroborate it. Look back to all the other pieces of evidence that match up to what Marquise Welch said. There were some things he couldn't get around. But he tries to lie about other things, right? He's asked during this trial and by detectives during the investigation, why were you going there? Why were you going to 47 Canton? Why are you taking the defendant to 47 Canton? Marquise Welch says, I have no idea. Do you really believe that? No. Do you really think that he had no idea why he was taking his friend to that street? That they weren't talking about it? Whether it be the week before, or the hours before, or at the video shoot, or in the car? Of course they were. That's what makes sense. And I ask you to use reason and common sense, and I think everybody does in this trial. And to make reasonable inferences from the facts you have. These guys are friends. They're hanging out all day. And the defendant's not going to say anything about why he wants to be dropped off in front of 47 Canton. Well, of course he did. But Marquise Welch isn't wanting to tell you that. So he's trying to get around that. What else does he try to lie about? He also tries to say, well, the defendant didn't say much when he got back into the car. Really? After the defendant comes running back, after he's just dropped off in the middle of the street, he comes running back, and he doesn't say much about what happened to Marquise Welch. Does that make any sense? Well, no. I mean, even when we heard from Marquise Welch, well, yeah, there was some kind of argument. The defendant was saying I wasn't going fast enough. You know, don't you think Marquise Welch is going to ask him, well, why? What's going on? Of course they're going to have a conversation. But Marquise doesn't want to tell you about that. Marquise Welch tries to say that he was threatened and coerced into saying that he heard the defendant say, I shot that bitch. You heard from Detective Bayless, who was involved in the proffer interview, that no threats were made to Marquise Welch. Of course, there might have been some pressure put on in an interview like that, right? Which is probably pretty understandable when you have witnesses. We heard about from Detective Bayless, witnesses aren't always eager and wanting to come forward to the police. And so often detectives have to deal with reluctant witnesses. So no threats were made, but maybe a little pressure to get to the truth, right? Because Detective Bayless said, we had all this other evidence and we knew it wasn't matching up, so they're trying to get Marquise Welch to tell the truth. There were no threats, but Marquise Welch is trying to get you to believe that now. You know, so do we think that Marquise knows more than he told us? Absolutely. Do we think Marquise Welch knows more than he told you? Well, absolutely. That's what the evidence shows, and that's what common sense and reason would dictate, that he would know more because he was with the defendant before and after. But as Mr. Faber alluded to in jury selection, that and in his opening, I believe, he talked about this will be a study in human nature, right? You're going to see the complicated dynamics associated with balancing self-interest, Marquise's self-interest, versus loyalty to a friend who just committed murder. And how far is Marquise Welch going to go in acknowledging his involvement in the murder? So Mr. Faber was absolutely right that you were going to see this study in human nature and that complicated balancing act, weighing the self-interest versus loyalty. And that's what you saw play out in the different statements of Marquise Welch. The investigation continues, and it reveals that Marquise and the defendant were at a video shoot on the day of the murder. So we know through the other evidence that the defendant and Marquise were at the Big Top. They were together. The investigation also shows they were at a video shoot later in the day. We know from Isaiah Smith himself, and also the rap video itself, that there was a video shoot that took place on December 26th, and it took place on College Avenue. During the investigator subpoena interview with the defendant, although we knew it from other means, right, from the video and from Isaiah Smith, the defendant also confirmed he was at the video shoot that day.
Yeah, well,
Leaving from where?
It was a little get together. He was having a little video shoot. My friend was, like I said, and he about locked up because he was going through some leaves and having a video shoot. Got intoxicated there, and I left from here, and I went home. I was drunk, so I was drunk.
Where was this video shoot?
It was on the north side. It was at a PRB, it's like one of them where they rent out the little townhouse, but it's on the north side, say college. It's like on college. How did that be nowhere? That was on college. Like closer going towards, like by the highway. College go past like a little highway, right? It's like a little bit, like before that. Like a little bit before that, and that's...
You were filming like a rap video?
I'm afraid he's a rapper.
So the defendant, in his own words, is confirming what the other evidence already showed. Because the evidence from the video shoot, from the portion of the music video that we had, it showed that the defendant was there. It showed that he was wearing that distinctive coat, dark on the top, light on the bottom, a black ski mask on his face, and that the defendant was in possession of a gun on that day. At various points, it's hard to determine, exactly the type of gun that he had on that day because of the lighting, But the defendant was clearly in possession of a gun. We see that from the music video itself, and Isaiah Smith also told you. Yes, the defendant had a gun. Numerous people handled the gun at the video shoot, but yes, the defendant had it. Either the defendant or Marquise brought it, because it wasn't there before they got there, but when they arrived, then the gun was there. And at the blue laser sight had been on it the whole time, and the gun arrived when Marquise and the defendant arrived. There are numerous different views of the defendant possessing that gun. All the evidence shows there was only one gun. It was a black gun. And all the evidence shows that the defendant had it at numerous points in that video. The gun had a blue laser sight attached to it. In this photograph, Isaiah Smith was holding it. But that is the same gun that arrived at the video shoot at the same time as the defendant. The one and only gun that was there that day, with a blue laser light. So as it relates to the gun and the blue laser light, we heard from Detective Sergeant Russell Karsten with the Michigan State Police, an expert in firearms. Among many other things that he told you, he said that all 3 9mm casings that he examined were fired from the same gun. That the primer strikes on the back of the casings were consistent with a Glock firearm. That the bullet was fired from a Glock barrel. Detective Sergeant Russell Karsten, along with Officer Bradley Cutright, 2 law enforcement officers with many, many years of experience, said that a blue laser sight is not very common. That it could come in different colors, right? But in all their years of experience, over 25 years, I believe, that a blue laser sight is pretty rare. It's not very common. That the more common colors of lasers are red and green. When he was saying that, it was interesting because the lasers even that we used here in this trial, the laser pointers, red and green. Blue laser sight, not very common. And then we also saw Detective Sergeant Karsten with his demonstration that the blue laser sight fit perfectly on the training gun that is used by the Grand Rapids Police Department, which is an exact replica of a Glock 17. And it wasn't too difficult to attach either. I think he did that in just a few seconds, if you notice, with a small screwdriver. Easily on, easily off. But that type of laser sight is specifically intended for a gun, not to attach to anything else. So the evidence in this case just shows more about the time frame or the timeline involved. After the video shoot, we know that they go directly to Canton Street, right? So from the video shoot, directly to Canton Street, because of course the defendant wants to go there. We know that the last outgoing call, which I believe we heard from Mr. Heikkila, not officer, the last outgoing call from the defendant on his phone was to Marquise Welch at 9:34 on December 26th. Last outgoing call. They leave the video shoot around 9:35. They head directly there. The cell data puts their phones off the towers near Canton around 9:47. The time of the gunshots, again, was 9:50. And in my previous slide, they were already heading westbound on Hall at 9:51. And interestingly, and I'm sure you took note of, that Marquise Welch, when you're considering, is he telling us everything he knows? Consider this fact. That Mr. Heikkila told us that from 9:44 to 10:04, there was no cell data for Marquise Welch. He turned off his phone or put it in airplane mode because we know that there was activity before and after, right? But during the exact time of the murder, between 9:44 and 10:04, no cell data for Marquise Welch. Why? Because he knew what was going on. He knows more than he's telling you. He turned off his phone. He didn't want to be associated with it. He didn't want anyone to be able to detect that. It was an intentional act on his part of turning off his phone or putting in airplane mode. So the investigators and detectives in this case, used all means that they had to find the truth, to figure out what happened. Another tool that you heard about here was the investigative subpoena. It's a tool that's used in these types of situations, right, where you may have some reluctant witnesses who aren't always eager to cooperate with the police. An investigative subpoena interview where that witness is given all of their rights and read their rights. They can have attorneys present. And that's what happened in this case. And why was the investigative subpoena important here? Well, you heard from the defendant. You heard his words from his mouth. And I asked you to consider, we've already talked about what did Marquise Welch try to lie about. Now consider, what did the defendant lie about during his IS interview? He lied about a lot. He lied about very important points in time, points that would connect him with this murder. And I'd like to go through some of those. So what did the defendant lie about during his IS? Mr. Faber asked him numerous times whether he was at or near 47 Canton on December 26th. And what was the defendant's answer? No, I was nowhere near there. Let's hear it in his words.
At the time that this murder occurred, were you present at or near 47 Canton Street Southwest? And that was December 26th of last year, about 9:50 p.m.
Because you keep saying last year, my bad. Because I keep saying, we in a new year. I'm like, you're saying the whole year. But no, sir. No.
Anywhere, do you know where you were that day?
Of course, he's trying to distance himself from the murder, right? He's asked those specific questions and denies being at or near 47 Canton. He's asked numerous times, and he lied numerous times. Let's hear his words again.
Do you know the address, 47 Canton? Let me show you a picture of the house. To the 15, and then it's the same answer, but it's also color. You recognize that house?
I ain't never been on Canton, the street. I don't know. Where is that? Where's the line?
Division,
Oh, I ain't never seen. I never been over there before, though, boss man.
So, that house, 47 Canton, on Exhibit 15, you've never been to that house?
I've never been to that house.
When you say you've never been, you mean never been inside? Or never been at the house outside of it?
I ain't never been by that house. I've never been. I don't.
Do you know anybody that is associated with that house? Anybody that stays there or stayed there?
I don't really do. That's not my side of town. Like, that's not. I can't even be over there. That is not my playground to be at. So I don't really. I'm from the south side, Venus area. Over there, I can't even go. Can't be around there.
The defendant was even shown a picture of the house. And he again lies and says, I've never been to that house, anywhere near that area. I don't know anyone associated with that house. Even though we heard evidence and testimony all about how one of his close friends, Terrell Franklin, has a beef or a disagreement with Omar Dana, who lives at that house. I mean, that's no coincidence. Again, defendant trying to distance himself with the murder. Defendant tries during his IS interview to distance himself with anything that can really connect him with the murder. And who's the closest person from December 26th that can connect him with the murder? Marquise Welch. So what else does the defendant lie about during his IS? He lies about being with Marquise Welch at the video shoot that day, and lies about being in the car with Marquise Welch that day.
Did you see him on December 26th? You've already testified about being at this video shoot at B&B on College. Was Keith there?
I don't know. I wouldn't know. I'm not knowledgeable enough. Because they would have gave me a ride then.
What's that?
I said he would have gave me a ride then. No, he wasn't. I don't know. No, he wasn't there.
He might have given you a ride there?
No, I said he would have gave me, I would have got a ride from there. Like, yeah.
But it's your testimony that you didn't?
No.
You don't?
No, he wasn't. I did not see him there. Like, he was not there. Like,
Did you see him at all that day?
yes.
Tell me where you saw him.
I saw him at my house. That little only last time I saw him was at my crib. He pulled up, said hello, because he lives right by me on 44th. His baby mom stayed on 44th. I live on 35 Keyante. I did live over there, except for 36, right there by my apartment. So he come like it's quick action. And like that's what I'm saying for that day, because the road was just, he was on his own 1, 2, 3. Like,
Did you talk to him that day?
Talked to him that day. He said I would talk to him, and that when he came, that's the only time I really got to talk to him. I didn't talk to him over the phone or nothing.
And other than, and was this at your place or in the parking lot?
That he pulls up to my place. He comes in.
And was he in that silver Dodge you testified to already?
Yeah, that's his mom's car.
Okay, that's the car that he drives all the time?
Yeah.
Did you get in that car that day?
No.
So the defendant denies during the IS interview ever getting into the car with Marquise Welch on that day. He denies him being at the video shoot on that day. The defendant tries to say, the only time I saw Marquise Welch was for a really quick, short time at my apartment. The defendant doesn't say anything else about being together at Big Top, being together at the video shoot, being together on Canton, being together after, being in the car with him. He lies about all of that. What else did he lie about? The defendant lied about possessing or even seeing a gun on December 26th. Again, on all these points that could connect him to this murder. The gun, Marquise Welch, those are the main things that the defendant is lying about.
Did you fire a gun that day?
No, sir.
Did you possess a gun that day?
No, I don't
Did you see a gun that day?
No.
We were just talking about a rap video, so it's completely different, but on College, at the B&B, during the video, I've seen enough videos to see that even if they're real or not, guns are very common props in your videos.
Right.
You know, is that fair to say?
Yeah, it is. That's the main thing that people put in their video.
If we get that video or videos that you were part of filming, are we going to see you with a gun in your hand?
No.
Okay. You're good. You're confident about that? I'm not trying to trap you. I just want to make sure that.
No. It's good.
Okay, so no, you did not possess a gun or anything that looked like a gun that day.
Hell no. No.
And so the defendant was asked if he possessed a gun or anything that looked like a gun that day. And what does he do? He doubles down. Hell no, he says. Well, we know that's a lie, based on all the other evidence in this case. We know that he possessed the gun, definitely looked like a gun. We know it was consistent and it looks like a Glock 17. We know he possessed the gun on December 26th, just in the hours before the murder. We know he possessed the gun on April 1st of 2022, in the months before the murder. You heard that once his phone was seized and collected from the search warrant in Lansing, it was forensically downloaded and examined by detectives. and that a photograph from April 1st of 2022 was located on the defendant's phone, showing a Glock firearm in his left pocket, and that was on his phone. I believe the witness identified that it was the defendant's hand, and that Coach wallet is consistent with the one that was seized from the 36th Street apartment. So this photograph shows the defendant holding a Glock firearm on April 1st of 2022. You heard from the detectives who conducted those searches, at the addresses associated with the defendant. Because at the time that he was taken into custody, that was from Lansing, right? But he was associated with other addresses, including the address of his girlfriend or fiance, Arafat. Officer Romero found an ID wallet and a phone in Lansing during that search. And that was the phone that was downloaded and showed the photo of the defendant with a gun on April 1st. Officer Cutright found the laser sight and the Coach ID wallet at the 36th Street apartment. And it was a laser sight that is specifically intended to mount on a gun. So it begs the question, where is the gun that attaches to that laser sight? He had the laser sight. It's reasonable to conclude that he got rid of the gun, but he still held on to that laser sight. And we know it fits on a 9mm Glock. We saw that demonstration here in court. And of course, the location where this laser sight is found is very telling, right? It was found in a place where the defendant hid it. That he hid it in a gift bag in a closet in what appears to be a child's room. He was trying to hide it. It wasn't found near some of the other stuff that was taken, but that's showing that his consciousness of guilt. He's trying to get rid of this, or at least hide it. We know he got rid of the gun and the coat, two things that are very able to link him to this crime, right? But he kept the laser sight, probably to attach it to another gun at some point. But he gets rid of the gun, he keeps the laser sight, and he hides it in a place that he hopes officers or anyone will find it. But luckily they do. And when it's activated by officers, it's a blue laser sight, again, that's very not common and rare. They find the Michigan hat and the Coach wallet during the search of the 36th Street apartment. The Michigan hat consistent, of course, with what the defendant was wearing on the day of the murder at the Big Top store. So all of these things taken together are showing the defendant's consciousness of guilt. He knows what he did, and his actions are showing that. That he is arguing with Marquise Welch that he wasn't going fast enough, as Marquise Welch is driving him away from the scene. He needs to go faster. He needs to go faster. The statement after the murder that he hears, the statement after the murder that he says, "I shot that bitch." He knows exactly what happened when he was at the door at 47 Canton, and he comes back to the car, running back to the car, and makes this spontaneous statement, acknowledging what he did. He stayed with Arafat after the murder, not his registered address that we see on his license or on his identification, or that he gives during his IS interview. He was found in Lansing. That'll be up to you to determine whether he fled to Lansing after this, or if he was just going to visit his aunt, as she would have you believe. But regardless, he was not found in the Grand Rapids area during the week after the murder. He went to Lansing. He got rid of the gun, but he kept the laser sight. He hides it in a bag in that room near children's clothing in a gift bag. Why is he keeping that? It's specifically intended to mount on a gun. Like I said, probably keeping it to attach to a different gun. And also, what else shows his consciousness of guilt in this case? All the lies, the numerous lies, the many lies he tells during the investigative subpoena. As we talked about during opening statement and jury selection, you know, what the standard here is that we fully accept, or what the burden is, that the elements have to be proved beyond a reasonable doubt. We talked about it's not to a 100% certainty, but it's a doubt based on reason and common sense, not something imaginary, but it has to be a doubt that could really, you know, attach to something based on the evidence or lack of evidence, a doubt you can articulate to fellow jurors. Not imaginary, not just possible, based on the evidence in this case. And there is no reasonable doubt in this case based on all the evidence that you have, all the overwhelming circumstantial evidence and direct evidence. You know, it's not reasonable doubt that there is no eyewitness to this crime, right? Eyewitnesses are direct evidence, but as we talked about earlier in jury selection, that can be subjective. That once you hear an eyewitness, you might question that, but that's subjective. It doesn't always speak for itself, like circumstantial evidence does. And in this case, the circumstantial evidence is overwhelming when you put everything together and everything matches up. Another jury instruction that you will get from Judge Quist, I believe, is that you should consider all the evidence that you have, right? You can convict solely on direct evidence, solely on circumstantial evidence, or a combination of everything that you have. So circumstantial evidence does not mean that it's any less than direct evidence. It's the quality of the evidence, not the type. And in this case, the circumstantial evidence and all the evidence together is overwhelming. The evidence shows that the defendant committed this murder. You know, I'm giving him all the benefit of the doubt based on the facts of this case. At the very least, you know, starting as a baseline, he is guilty of second-degree murder. You will be able to determine the degree of murder that he is convicted of. You will be able to decide between first-degree murder and second-degree murder. And again, I submit to you at the very starting at a baseline is he is guilty of second-degree murder. These are the elements that have to be proven beyond a reasonable doubt in order for him to be convicted of that charge. That first, he caused the death of Mya Kelly. And second, that he had one of three states of mind. And I ask you to keep in mind that here, for second-degree murder, a person does not have to intend to kill or have the intent to kill to be guilty of this charge. The person has to have one of three states of mind. Intent to kill, intended to do great bodily harm, or knowingly created a very high risk of death or great bodily harm. You know, like in a case like this, where shooting through the door when the defendant knew someone was on the other side of it, because the evidence shows he was having some conversation with Mya Kelly. He knew she was there. At the very least, he knowingly created a very high risk of death or great bodily harm, at the very least. That's why I say start with that as your baseline, that he is guilty of second-degree murder. But I submit to you, he is guilty of first-degree murder. And that's what I ask you to hold him accountable for, is first-degree murder. And as we talked about before, even if you believe that that the bullet or the bullets were intended for Omar and struck Mya instead, the crime is the exact same under the law of transferred intent. The evidence shows that the defendant is guilty of first-degree murder because these 5 elements have been proved beyond a reasonable doubt. That the defendant caused the death of Mya Kelly, that he intended to kill, the intent to kill was premeditated, the killing was deliberate, and that the killing was not justified, excused, or reduced to a lesser crime. So one of these elements that you have to decide, of course, is whether the intent to kill was premeditated. So premeditation, as you will get these jury instructions as well, it means that it's up to you to decide if enough time passed under the circumstances of this case. The law does not say how much time is needed. You know, but from shows and television and movies, when the concept of premeditation is thrown around, you might think that it requires days, weeks, years of planning, writing it down, things like that. That's absolutely not required. Premeditation can form in the matter of seconds. The law does not say how much time is needed. It is up to you to decide if enough time passed under the circumstances of this case. So in order to determine that, if enough time passed, I ask you to look at all of the defendant's actions, break them down, and look at how many decisions that he had to make. You know, the idea is that there has to be enough time to think twice, right? To have a second thought about it, not to be just a sudden impulse. And all the evidence here shows that the defendant thought about this for a while. Whether it be the week before, or hours before at the video shoot, or on the way there, or as he was walking up. There are many different facts that show premeditation. The defendant tells Marquise to take him to Canton Street. Take me there. He's already thinking about what he's going to do. They drive around the block to canvass the area. All acts of premeditation. He gets out the second time that they go around the block. He has to get out of the car. He goes armed with a Glock. That's a deliberate action, an intentional action. He has to walk up to the house after getting dropped off, getting out of the car, opening the door, getting out, walking up to the house. He has all of this time to think about what he's going to do. He has time to think twice. He knocks on the door. Not just once, but he knocks on it twice. He says something to Mya. He tries to get her to open the door. We heard from Omar Dana that the defendant, tried to disguise his voice. It sounded like a weird voice. The defendant also, tries to avoid detection because Mya Kelly didn't see anyone out of the peephole. So it's reasonable to conclude that the defendant was trying to hide himself. He's taking that act for action as well. He knocks on the door again. These are all separate acts of premeditation that show what the plan was. And all the actions that I just described don't even take into account any planning that went into it beforehand, right? Those actions are just when he goes there from the video shoot. It doesn't take into account any planning that might have happened at the video shoot itself, or in the hours before, or in the week before, when Terrell Franklin and the defendant, are mad that Terrell Franklin got arrested from 47 Canton because Omar and Mya may have snitched on him. We know there was some sort of plan. The defendant knew exactly where to run. How did he know exactly where to run after he shot Mya Kelly? We saw in the video surveillance that there was many places that Marquise Welch could have parked, right? In driveways, along the street, in the other direction. But the defendant knew exactly where to run. Why? Because they talked about it. Because there was a plan about it. That Marquise Welch would back into that space and wait. All separate actions of premeditation. The evidence shows the defendant is guilty of first-degree premeditated murder. It also shows that he is guilty of carrying a concealed weapon. To prove this charge, the prosecutor has to prove these two elements: that the defendant knowingly carried a pistol, and that the pistol was concealed on or about his person, or the pistol was concealed in a vehicle, or the pistol was in a vehicle, and that the defendant was in it, he knew it was there, and he took part in carrying it or keeping it there. Importantly, you should note that there is no requirement that if it's in the vehicle, that it be hidden or concealed. It just has to be in the vehicle that the defendant was in, he knew it was there, and he took part in carrying or keeping it in the vehicle. The evidence shows he is guilty of that count as well. He is guilty of possession of a firearm, because these elements have been proven beyond a reasonable doubt, that he knowingly possessed or used a firearm in this state, and that he was ineligible to possess a firearm. As it relates to count 2, element 2, there is a stipulation about that. So the defendant stipulates or agrees that he was ineligible to possess a firearm at the time of these acts. He is guilty of that count as well. The evidence shows he is guilty of felony firearm. In order to convict him of that count, you would have to find that the people have proven beyond a reasonable doubt that he committed the crime of murder. That's what the evidence shows in this case, that he is guilty of first-degree murder. And then when he committed that crime, he knowingly carried or possessed a firearm. So after you've heard all this evidence and sat through the course of this trial, the evidence shows that these three men were linked. They were connected. They were friends. They may have had motive here. And regardless of what was going on with these three men, it did not need to end in the death of Mya Kelly. You know, the defendant that day had really no regard for human life. As he was shooting through that door that he knew someone was on the other side of. He knew there was a female voice speaking to him. You know, and thank goodness those kids weren't struck as well, because they very well could have been. So no, they are not victims of this murder. But they are still victims, right? I mean, they have to continue their lives without their mother and have this image in their minds forever of their mother being shot in front of their very eyes. I'm asking you to hold the defendant accountable for that. He had the means, he had the opportunity. You hear his words that he lied so many times to distance himself from what he just did. All the direct and circumstantial evidence in the big picture shows that he is guilty, and that I ask that you return the only just verdict in this case, which is guilty of first-degree murder, possession of a firearm, carrying a concealed weapon, and felony firearm. Thank you.
Thank you, Ms. Pravat. Mr. Kirkhoff, ready to proceed? Okay, please do so.
I get to address you one time. Ms. Pravat gets a chance to come up and talk to you again. And I'm going to ask, because I only get one shot at you, to listen to me and to actually pay attention as best as you can. And I'm not going to take anywhere near what she took, because I don't have to build a house of cards. All right. Ms. Pravat's whole argument is, if it fits my theory, it's true. If it doesn't fit my theory, somebody's lying. That's not how beyond a reasonable doubt works. I'm going to ask you to listen to everything and take everything into consideration. And just because it doesn't fit her theory, don't throw it out. You know, look at everything. And let's start with this motive part. Now, the judge is going to instruct you. They don't have to prove motive. What did she spend half of the trial trying to do? Motive, where there's no motive for my client to do anything. This bit about he's friends with Terrell. Terrell gets thrown in jail a week ahead of time. It's absolutely without a doubt my client knows Terrell. My client was even there earlier but left. He had no cat in that fight, period. And he told you that. All right, while I was on the investigative subpoena anyway. But he didn't have anything to do with it. And what did Omar say on the stand? Terrell called me from jail a bunch of times after he got arrested. Now, as you might expect, our jail is set up. Yes, occasionally they are given a chance to make outgoing calls. Can I call somebody in their cell? No, it is a jail. Mr. Terrell Franklin had to place the call, and he's placing the call to his former buddy with whom he got into an argument about pissing on someone's grave that has nothing to do with my client. And what does he tell you? Yeah, he says, Omar told you, I told Terrell when he called me, I didn't snitch on you and Mya didn't snitch on you. And I asked him, well, that kind of settles that, didn't it? And he said, well, not really, we still weren't happy, but. So there's an explanation, and Terrell calls him again after that too. Did Terrell ever call my client and say, hey, go shoot somebody because I got mad at him once? Absolutely not. No communication with my client and Terrell while Terrell's in the jail after he gets arrested for whatever the heck happened in this cemetery that my client wasn't even there. And Ms. Provette gets into an argument with her own witness, with Omar, about it, trying to get him to say, well, yeah, this must have been why it happened. And he couldn't say it and didn't. And gets into an argument with her own client, or own witness about it. There's no motive for my client to do anything, and he didn't do anything. Now, she is relying a lot upon what's in the investigative subpoena of my client. What does my client say right at the very beginning? Well, let's back up a little bit. He gets arrested around 8 o'clock in Lansing, is brought back here directly, and by 11:20 is what the investigative subpoena says, he's being questioned under oath about this incident. And what's the first thing he says? Hey, I'm still drunk from last night. I'm high. I'm on coke yet. I haven't had any sleep. And you saw his demeanor on there. He'd start laughing, or not laughing, maybe not laughing, but chuckling at inappropriate times. His answers were mostly, cogent, but his whole demeanor supported the exact fact that he was in an altered state of mind at the time of the investigative subpoena. Were all of his answers perfect and, quite frankly, truthful? I doubt it. But again, he's in an altered state of mind. He's brought into a court, sworn in, and asked questions. And he might have had an attorney there, but did you see the attorney say anything to him at all during the whole time? No. And let's look at a couple of the things that matter here. Marquise Welch, I quite frankly don't know how to take his testimony. I don't know how to take what he said. Marquise Welch, according to the prosecutor, knew everything was going to happen. He drove the getaway car. He knew this was going to happen. That's why he turned off his phone. They had this discussion in the car ahead of time where there's absolutely no testimony, no evidence of any of that sort of thing happening. Marquise Welch, I don't know how much of what he said was the truth and how much it wasn't, but according to Ms. Provette, you believe if it fits my theory. If he doesn't fit my theory, he's lying. That is not how one determines whether someone is lying or not. And let's look at what Mr. Welch had on the plate to determine, what you can believe and what you can't believe. He had gotten arrested for having a bunch of fentanyl on him. He was charged with that. He had a couple of cases he was on bond for that was a violation. And according to them, he knew this was all going to happen. He was the getaway driver. He's the one that drove him there. They talked about it ahead of time. He knew she was, that Mr. Newbern, who was supposed to be in his car, was going to get out and shoot somebody. Was he charged? No. All he had to do was tell them what they wanted to hear. That's exactly what he said up there. He said he told them what they wanted to hear. They grilled him for an hour at that one point, and that wasn't even the whole he was only, the transcript that we have is only part of it. It doesn't show, it's not the whole thing. Now, was he threatened about having to go to prison I'm sure he was, because quite frankly, he should have, based upon being arrested with 8 grams of fentanyl in his pocket, being on conditional bond. All that dictates that's probably going to prison. Was he? And they're adamant that he lied throughout his investigative subpoena. Was he ever charged with perjury? No. He found a get out of jail card. And that's telling what they want to hear. Did he ever get charged with the accessory after the fact for this murder, or even with the murder itself, which they could have? No. He found a get out of jail card. And he said, I played it. I told them what they wanted to hear. What specifically did he say he lied about, at least in front of a jury? He said, well, this person in the car, Mr. Newbern, supposedly, never said anything about I shot that bitch. I made that up. I also made up the part about go, 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 you got to go faster. It worked. He didn't get charged, and he only got a year in the county when he should have been going to prison. So what he said worked. It was in his best interest to tell them exactly what they wanted to hear, and that's exactly what he did. Now, I'm sure she's going to get up and say, well, that's a lie. But let's look at one corroborating thing. The only thing we can find here is Ms. Hines. Ms. Hines gets in the car after all this is supposedly done, and Mr. Newbern's in the back seat of the car, and as she put it, he's intoxicated. I get in, he says, what's going on, or how you doing, or whatever. And outside of that says almost nothing. Now, what did Ms. Hines first tell the police? I can't recognize him. The guy, I've never met him. The guy was wearing a mask. All I could see was his eyes. I can't tell you who it is. Now, what happens when we get to court? Well, she wants to be very helpful for the police. Oh, that's definitely him. I recognize him by the eyes. Even though she already said a couple times, I can't say for sure. She is doing everything she can to help the police. What does she say? He doesn't say anything once I get in other than saying hi or something like that. We pass around the joint. He's intoxicated, laying down in the back. He doesn't say anything. Now, do you think if he would have said, hey, I shot that bitch, you think that would have come out on Ms. Hines' testimony? Certainly would have. She was bending over backwards to help the police here. It didn't come out because it was never said, and at least in that regard, Mr. Welch is telling the truth. And that is corroborated. Now, Ms. Prevet has brought up a number of other things, including things like, well, he had to have gotten rid of the coat and the gun. Obviously, a gun can be incriminating, particularly if it's used in a murder or any other kind of a shooting. But what about this coat? How would Mr. Newbern know that that is incriminating? He wouldn't have. He didn't get rid of it. They just, I don't know where it is. They didn't find it. Maybe it's still at his mother's. But if you're going to get rid of stuff that's incriminating, you get rid of stuff that's incriminating. You don't keep a laser sight that would have been used in a murder if, in fact, it was used. And again, the police, well, golly gee whiz, I've only seen red or green laser sights. I've never seen blue, but they're readily available. Of course, none of them ever look to see what color it comes in or how often it's used. Now, Russell Karsten did admit there's millions of Glocks out there. And he did not put a number on it, but he said there are innumerable laser sights in numerous colors. At least that part, perfectly honest with. But Ms. Prevet goes even farther and says, hey, the laser pointers we have in court are red and green. That means Mr. Newbern did this. Her whole case is supposition upon supposition. It is a house of cards where you take one out and they all collapse. And And that's not beyond a reasonable doubt. In order to get a conviction here, you have to believe this, then you have to believe that, then you have to believe the next thing, then you have to believe the next thing, and ignore anything that is contrary to that. I mean, Ms. Prevet's up here saying her Grand Rapids police officer who testified is a liar. There is no doubt in my mind that Omar Dana, rightly or wrongly, at some point prior to this tape that you can play if you want, you notice it starts with him getting in the car. Doesn't start with him the first time that he is encountered by Officer Van Vliet. Officer Van Vliet was very adamant. Yeah, he told me that. He told me the door opened, there was an argument. Now, did that happen? I don't know. But why would Officer Van Vliet make that up? The one thing that does matter here is he said, yeah, it was a really weird voice and it was a white voice. Mr. Newbern's not white. But so Ms. Prevet knows that's the problem, so what does she say? The cop is mistaken. Lying, in other words. He testified under oath. Yes, Mr. Omar Dana said that to me. Who are we going to believe? I know who I believe. Certainly isn't Omar Dana over Officer Van Vliet in that situation. Now, there are certain things here that don't make sense whatsoever. That is number one. The white voice that Omar Dana heard at the door and now realizes it doesn't comport with the prosecution theory. Therefore, it didn't happen, despite what Officer Van Vliet is saying. There's other things. Jennifer Stradilak, who is a IBO tech with Grand Rapids, said, I collected GSR on Omar's hands. Collected, not tested. And she said GSR is gunshot residue. She collected gunshot residue on his hand. Did he do the killing? I don't know. But that certainly is something that the prosecution chooses to ignore. The Atkinsons. They see this black car going down the street. And it's, they saw it a few seconds after the shooting. It was going real slow, and I found that to be odd. Both of them said that. But now, according to Ms. Prevet, that doesn't fit with her theory. So, there's 20 or 30 seconds afterwards, and now you see it coming in front of 23 Canton, which is all the way down the street. And therefore, if they would have been involved, they would have been fleeing. I don't think that quite fits either. If someone from that car shot, number one, they'd have to get back in the car and go back. And number two, if they knew that they did the shooting, they may speed away. But they don't have to because they know no one else is going to be shooting, as opposed to somebody running who might have heard shots in the area. And again, if it doesn't fit, you have to ignore it according to Ms. Prevet. But that is, again, not beyond a reasonable doubt. At 9:34:17, Mr. Newbern's phone places a call to Mr. Welch's phone. We have the phone records. No doubt about it. Why do you call somebody? Because they're not next to you. They're not standing together. And that would have been at the video shoot. And as Mr. Newbern said in his, his investigative subpoena, he got a lift home from that, didn't ride with Mr. Welch. That would make sense if a few minutes before that, Mr. Newbern is calling Mr. Welch. Wouldn't be calling him if they were sitting next to each other at a video shoot. And one last thing in connection with that. The last thing I asked Mr. Welch was, didn't you go pick up Mr. Newbern before you went to Caitlin's? And he said yes. again, I'm sure Ms. Pravett's going to get up here and say, well, you had to be lying about that because it doesn't fit our theory. But the fact remains, Mr. Newbern was not with Mr. Welch until Mr. Newbern, well, after the video shoot, until Mr. Newbern got picked up by Mr. Welch on the way to Caitlin's. And what did they say? They lived right in the same apartment complex right around the corner from there. So I guess we don't really have a problem with Mr. Newbern being in the back seat of Mr. Welch's car at Ms. Hines' house because he just got picked up by Mr. Welch, who admitted he just picked him up. I'm guessing, and again, here I'm guessing, and I'm telling you I'm guessing, that they went together to this shoot. Everybody kind of, I guess, agreed that Welch left the shoot to go get food. And Mr. Newbern told you in his IS he wasn't there to give him a ride, so he took a lift. But about I don't know, not too much longer later after that, Mr. Newbern comes, or Mr. Welch comes and picks up Mr. Newbern, and they go over to smoke right around the corner with Ms. Hines. And again, no questions asked by Ms. Pravett after Mr. Welch said that. But now I'm sure there's going to be something said about it, that he's obviously lying in that part because it doesn't fit with our theory. Bottom line here is there are just too many holes in this. This is supposition upon supposition. It's a house of cards. You pull one out and the whole thing collapses. Mr. Newberg did not commit this murder. Was he with some of these people? Sure, earlier in the day, yeah. And later in the day, yeah. But he was not there, and they have not shown anything that proves he pulled the trigger in this matter. Thank you. I'm asking that you return a verdict not guilty on everything.
All right, thank you, Mr. Kirchhoff. Ms. Pravat, rebuttal, I'm going to limit it to 15 minutes.
Your Honor.
I'd just like to touch on a few things, and to start off, Mr. Kirchhoff tries to tell you that I'm only asking you to believe the portions of Mr. Welch's testimony that fits with my theory. Well, that's not accurate, because when I stood up here before, when I acknowledged you'll probably have to consider what you believe from Mr. Welch, I asked you to believe the parts that fit with all the other evidence in this case. My theory in this case is based on the evidence. So I ask you to believe the parts of Marquise Welch's testimony that fits with all the other evidence in this case, not that it just fits with my theory. My theory is based on the evidence. And of course, you heard that Marquise Welch received some type of offer from my office for his truthful testimony during this trial. So yes, in some ways he cooperated, and that was in his own self-interest. And you might not like the fact that an offer was given to him. And you know what? Quite frankly, neither do we. But his cooperation was what helped lead to discovering who the killer was in this case. And it led to the defendant. So although you might not like the offer, we don't either. Sometimes in cases like this, we need to have some cooperation to figure out the truth. So he was acting in his own self-interest, yes, but his testimony and what he told us is based on and matches up with the other evidence in this case. Mr. Kirchhoff said I got into an argument with Omar Dana. Well, I submit to you that Omar Dana was another reluctant witness. Like we've seen from the others, like Marquise Welch and Jasper Keys and Caitlin Hines. Then when I was asking Mr. Dana, tell me why this happened. Why do you think this happened? Were there some reasons for it? That's when he did not want to go into a lot of details, right? He didn't want to talk about that either. Maybe he didn't want to snitch either. We've heard, and I'm sure you can see during the course of this trial, that snitching is a big deal. It can be life or death. And Omar Dana was another witness who was showing you, that he didn't want to talk about certain things. Mr. Kirchhoff said that I stood up here and said Officer Van Vliet was mistaken because it doesn't fit with my theory. No, I said that because it doesn't fit with the evidence. I asked Officer Van Vliet, I believe at least a couple times, were any of the conversations that you had with Omar Dana captured on your body-worn camera? Yes, he said. I asked, were there any other conversations that weren't captured on your camera? No. So any conversation you had with Omar Dana would be captured on that camera? He said yes. And so that's why I played it for you at least 2 times, and of course you can go listen to it again. So I say that he was mistaken because that's not what the evidence shows. That body-worn camera shows that Omar Dana never said Mya opened the door and never said that there was an argument. He said the door, that she went towards the door, and that there were words exchanged. So why I said that was based on the evidence. The defense is trying to claim that at the investigative subpoena interview that the defendant was intoxicated. Well, you have that yourselves, and you've seen it here in court, and you can look at it again. But ask yourselves, what symptoms of intoxication is he showing? You know, Mr. Kirchhoff points to the fact that he was laughing during that. That must mean he was intoxicated or high. But I submit to you that the defendant was laughing during the course of this trial at various points. So it's not necessarily a symptom of being high or intoxicated. It's probably just his demeanor. Because Mr. Faber even asked him during that IS interview, well, you know, essentially you say you're intoxicated, but you seem to be understanding me. Defendant says, yes, I'm comprehending. There's nothing else in his demeanor indicating that he doesn't understand the questions or that he doesn't understand what's going on. Just because he was laughing in that IS interview does not mean he was drunk or high. Again, he was laughing at various points during his murder trial. Mr. Kirchhoff talks about some of the evidence that we didn't find, right? Like the coat and the gun. So things that it's reasonable to conclude that the defendant would have gotten rid of, because those items would have been very strong connections to this murder, and he knew that. I mean, is it really that shocking to you that a criminal would dispose of a gun that had just been committed, that had just been involved in a murder? Is that shocking? Absolutely not. I mean, isn't that what you would expect him to do? To dispose of the gun, dispose of the coat. It's exactly what he did. Please don't reward him for being smart enough to get rid of the gun and get rid of that coat. That's exactly what you would expect a person to do in these circumstances. And Mr. Kirchhoff says that we can't prove that he had a gun or that he fired a gun or that he possessed a gun. But if you look at the photos or the video that you have from the video shoot in the hours before the murder, and you look at the picture of the gun in his hand. If we could pull that up. The defendant clearly has a gun in his hand at the video shoot hours before the murder. And the gun is consistent with being a Glock 17. Could we dim the lights, please? You saw the demonstration in court and you heard the testimony about this training gun that's used by the Grand Rapids Police Department. That's an exact replica of the Glock 17. And I asked you to look and compare it to the similarities of the gun that was in the defendant's hand on December 26th of 2022 in the hours before the murder. And if you look at some of these characteristics of the trigger guard, and I'm holding it in a way that's very similar to what we see in this photograph up here. But look at the trigger guard, the space between the trigger guard and this laser sight, this little notch or divot right here that you also see in this image. the space between the trigger guard and the laser sight that you see on this training gun, and that you also see in this image, and the distinctive trigger guard here that's consistent with what we see in this image. So this gun, although we can't say for certain what it is in this video, it is consistent with being a Glock 17 based on all the other evidence that we have when comparing it to this training gun that's an exact replica of a Glock 17 that's carried by Grand Rapids police officers. With this laser sight attached, this is exactly what the Glock 17 would look like, and that's exactly what we see up here in the defendant's hands hours before the murder on December 26th. Again, don't reward him for being smart enough to get rid of that gun and get rid of the coat. All the other evidence that was found and shown to you during the course of this trial shows that he is guilty. All the evidence taken together is overwhelming, and I ask that you hold him accountable of first-degree murder and all the other related charges. Thank you.
Thank you, Ms. Brevet. Okay, we're going to pass out some jury instructions. I'll just let you guys know that I have some limited control over how long it takes the attorneys to do what they need to do. What takes me, what'll take me to do if you could begin deliberations will be about 25 minutes. So I think we should just soldier on through these jury instructions, which I have to read into the record, and hopefully get deliberating by about 2:15 or so. Okay. Once everyone gets a copy, I'll read these into the record, and I have a few other things to do before we get you back into the jury room. All right, looks like everyone has a copy. I do need to read this into the record under the court rules. So, members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy or prejudice influence your decision. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times I have already given you some instructions about the law. You must take all of my instructions together as a law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of this case are, to apply the law as I give it to you, and in that way to decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of the witnesses, the exhibits admitted to evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments and any commentary are not evidence. They're only meant to help you understand the evidence in each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you have of a place, person, or event. To repeat once more, you must decide this case based only on the evidence that was admitted during this trial. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have based on race, gender, or national origin of the witness. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It's also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. When the lawyers agree on a statement of facts, these are called stipulated facts. You may regard such stipulated facts as true, but you are not required to do so. You have heard testimony from police officers. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. You've heard testimony from expert witnesses. Experts are allowed to give opinions in court about matters they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts the expert gave for his or her opinion and whether those facts are true. You should also think about the expert's qualifications and whether his or her opinion makes sense when you think about the other evidence in the case. Some witnesses testify by video conferencing technology. You are to judge the witness's testimony by the same standards as any other witness, and you should give the witness's testimony the same consideration you would have given it had the witness testified in person. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the alleged crime. They only have to show that the defendant actually committed the crime and that he meant to do so. Before you may consider what Marquise Welch said in court, you must decide whether he took part in the crime the defendant is charged with committing. Marquise Welch has not admitted taking part in the crime, but there's evidence that could lead you to think that he did. A person who knowingly or willingly helps or cooperates with someone else in committing a crime is called an accomplice. When you think about Marquise Welch's testimony, first decide if he was an accomplice. If, after thinking about all the evidence, you decide that he did not take part in this crime, judge his testimony as you judge that of any other witness. But if you decide that Marquise Welch was an accomplice, then you must consider his testimony in the following way. You should examine an accomplice's testimony closely and be very careful about accepting it. You may think about whether the accomplice's testimony is supported by other evidence, because it then may be more reliable. However, there's nothing wrong with the prosecutions or prosecutors using an accomplice as a witness. You may convict the defendant based only on an accomplice's testimony if you believe that the testimony and it proves that the defendant's guilt, and it proves the defendant's guilt beyond a reasonable doubt. When you decide whether you believe an accomplice, consider the following. Was the accomplice's testimony falsely slanted to make the defendant seem guilty because of the accomplice's own interest, bias, or for some other reason? Has the accomplice been offered a reward or been promised anything that might lead him to give false testimony? Has the accomplice been promised that he will be prosecuted or has the accomplice been promised, this is what happens when you read continuously for several minutes. Has the accomplice been promised that he will not be prosecuted or promised a lighter sentence or allowed to plead guilty to a lesser charge? If so, could this have influenced his testimony? Does the accomplice have a criminal record? In general, you should consider an accomplice's testimony more cautiously than you would that of an ordinary witness. You should be sure you have examined it closely before you base a conviction on it. You have heard that before the trial, a witness made statements that may be inconsistent with his or her testimony in court. You may consider an inconsistent statement made before the trial only to help you decide how believable the witness's testimony was when testifying here in court. If the earlier testimony or statement was made under oath, then you may also consider the earlier statement as evidence of the truth of whatever the witness said in the earlier statements when determining the facts of this case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that he did not testify. It must not affect your verdict in any way. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and the evidence you believe proves beyond a reasonable doubt that the defendant is guilty. Count 1, first-degree premeditated murder. The defendant is charged with the crime of first-degree premeditated murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Mya Kelly, that is, that Mya Kelly died as a result of the defendant shooting her with a firearm. Second, that the defendant intended to kill Mya Kelly. Third, that this intent to kill was premeditated, that is, thought out beforehand. Fourth, that the killing was deliberate, which means that the defendant considered the pros and cons of the killing and thought about and chose his actions before he did it. There must have been a real and substantial reflection for long enough to give a reasonable person a chance to think twice about the intent to kill. The law does not say how much time is needed. It is up for you to decide if enough time passed under the circumstances of this case. The killing cannot be the result of a sudden impulse without thought or reflection. Fifth, that the killing was not justified, excused, or done under circumstances that reduce it to a lesser crime. Next, second-degree murder. You may also consider the lesser charge of second-degree murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Mya Kelly, that is, that Mya Kelly died as a result of the defendant shooting her with a firearm. Second, that the defendant had one of these three states of mind. He intended to kill, or he intended to do great bodily harm to Mya Kelly, or he knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of his actions. The defendant's intent may be proved by what he said, what he did, how he did it, or by any other facts and circumstances in evidence. If the defendant intended to kill one person, but by mistake or accident killed another person, the crime is the same as if the first person had actually been killed. You must think about all the evidence in deciding what the defendant's state of mind was at the time of the alleged killing. The defendant's state of mind may be inferred from the kind of weapon used, the type of wounds inflicted, the acts and words of the defendant, and any other circumstances surrounding the alleged killing. You may infer that the defendant intended to kill if he used a dangerous weapon in a way that was likely to cause death. Likewise, you may infer that the defendant intended the usual results that follow from the use of a dangerous weapon. A gun is a dangerous weapon. A dangerous weapon is an instrument that is used in a way that is likely to cause serious physical injury or death. Premeditation and deliberation may be inferred from any actions of the defendant which show planning or from any other circumstances surrounding the killing. The prosecutor need not prove a motive for the killing, but you may consider evidence of motive in deciding if there was premeditation and deliberation. Motive by itself does not prove premeditation and deliberation. Next, count 2, carrying a concealed weapon, a pistol, on person. And I'll clarify this because there's also part of it in a vehicle, but I'll clarify that when I'm talking about the jury verdict form, okay? The defendant is charged with the crime of carrying a concealed pistol. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant knowingly carried a pistol. It does not matter why the defendant was carrying the pistol, but to be guilty of this crime, the defendant must have known that he was carrying a pistol. Second, that this pistol was concealed on or about the person of the defendant. Complete invisibility is not required. A pistol is concealed if it cannot easily be seen by those who come into ordinary contact with the defendant, and or carrying a concealed pistol in a vehicle. The defendant is charged with the crime of carrying a pistol in a vehicle. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that a pistol was in a vehicle that the defendant was in. Second, that the defendant knew the pistol was there. Third, that the defendant took part in carrying or keeping the pistol in the vehicle. Next, count 3, possession of a firearm. The defendant is charged with the crime of possession of a firearm when he was ineligible to do so. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant knowingly possessed or used a firearm in this state. Second, at that time, the defendant was ineligible to possess a firearm. The defendant stipulates that he was ineligible to possess a firearm at the time of these alleged events. Next, count 4, felony firearm. The defendant is also charged with a separate crime of possessing a firearm at the time he committed the crime of murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant committed the crime of murder, which has been defined for you. It is not necessary, however, that the defendant be convicted of that crime. Second, that at the time the defendant committed that crime, he knowingly carried or possessed a firearm. It does not matter whether or not the firearm was capable of firing a projectile or whether it was loaded. A pistol is a firearm. There has been some evidence that the defendant was voluntarily intoxicated with alcohol or drugs when the alleged crimes were committed. Voluntary intoxication is not a defense to the crimes of open murder of Mya Kelly, carrying a concealed weapon, possession of a firearm, and felony firearm. So it does not excuse the defendant if he committed these crimes. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about December 26, 2022 within Kent County. The defendant is charged with counts, that is, with the crimes of open murder of Mya Kelly, carrying a concealed weapon, possession of a firearm, and felony firearm. These are separate crimes, and the prosecutor is charging that the defendant committed all of them. You must consider each crime separately in light of all the evidence in the case. You might find the defendant guilty of any or all or any combination of these crimes, guilty of a less serious crime, or not guilty. When you go to the jury room, you will be provided with a written copy of the final jury instructions. In fact, all of you have a copy right now. You should first choose a foreperson. The foreperson will see to it that your discussions are carried on in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you'll discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement, express your opinions and reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because the other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own and you must vote honestly and in good conscience. If you have any questions about the jury instructions before you begin deliberations or questions about the instructions that arise during deliberations, you may submit them in writing in a sealed envelope to the bailiff. Possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to the bailiff. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and full instructions. If you want to look at any and all of the reference documents or exhibits that have been admitted, just ask for them. Okay, 16 pages. It's kind of a marathon for instructions, but we got through them. All right, at this point, we're going to display the verdict form, and I'll explain that to you. You'll be getting one copy of this. You'll ultimately give it to whoever you choose as the foreperson. And this is your job, okay? You have to decide on your verdict, and after you decide on your verdict, you have to complete this form. Have the jury foreperson complete it. The first part of it is just kind of the caption of the case, and then it says, we the jury find defendant Keyante Newbern. It says, mark only one line per count. So count 1 is first degree premeditated murder. You have 3 options there: not guilty, or guilty of first degree premeditated murder, or guilty of the lesser included offense of second degree murder. So you can find him not guilty, guilty of first degree murder, or second degree murder. Those are the 3 options for count 1. Count 2 is a little unusual, I'll say. The prosecutor provided this information that I read at the beginning of this trial, and they have 2 theories for carrying a concealed weapon, okay? One is that Mr. Newbern was carrying a concealed weapon on his person, and one in his vehicle. If you find him guilty of one of those, then he would be guilty of the carrying a concealed weapon, okay? If you find that he carried a concealed weapon on his person, you don't need to consider the vehicle, or vice versa. Just one of the 2. It's an alternate thing. So person or vehicle will suffice to find him guilty on carrying a concealed weapon, or of course you can find him not guilty on count 2. Count 3 is possession of a firearm. Again, that's self-explanatory, not guilty or guilty. And then finally, felony firearm, not guilty or guilty. Then once you've reached your verdict, the foreperson has to date and sign that document, and then you have done your job. And then ultimately, we'll have the verdict read into evidence once you return with that verdict. And my clerk will tell you how that's all going to work, but that will be after you decide the verdict itself, and then we'll come in here and announce it. Okay. You can jump around between counts if you want to, and that will that's how we'll handle that. Ladies and gentlemen of the jury, during the course of this trial, I have given you some oral instruction, some written instructions as well as oral instructions. If you feel that you need any of my oral instructions in written form, please have your foreperson write a note for that specific instruction, and I will give it to you. Okay, we have to do something I always find to be unfortunate, because under the law in the state of Michigan, a case such as this has to be decided by 12 people. So we have to draw 2 people off as alternate jurors. If you are an alternate juror, if your name is called, come right before me just for a second. I have to tell you a couple things before you leave. So we're going to have to draw 2 people off at this point. Go ahead, Mr. Wood.
Capsule number 10, the juror in seat 7, Timothy Hetzer.
Oh, yeah, come over here, but that camera should be nowhere near the jurors. Come up here, sir.
Capsule number 39, the juror in seat 5, Antonio Silva.
Okay, gentlemen, you are what we call alternate jurors. I wish to tell you, you're done with the process. You're not quite done. All right, this is what's going to happen in very rare circumstances, and it happens much less than 10% of the time. Let's say during deliberations, one of the jurors gets sick or gets called away on an emergency. If that happens, an alternate juror can be called back, and you have to start deliberations all over again. It's very rare that it happens, but it does happen occasionally. So you're still bound by your oath not to talk to anyone about the case, do anything, any research about the case. You're still completely bound by your oath. Once a verdict is reached, however, we will have the jury clerk call you, and then once they do that, then you can discuss the case with anyone. Okay, gentlemen? Thank you very much for your service. Ms. Dilworth will let you back out into the jury room to get your personal belongings. I appreciate you sitting through this trial. Thanks, gentlemen. Okay, you're the 12 people that are going to decide the case at this point. I did want to tell you something about time control. As far as breaks and things like that, you guys have already had a lunch break, but if you want to take long or short breaks, it doesn't matter to me. You control how long your breaks are. What I control basically is when court begins and ends at the end of during the day. The Kent County Sheriff's Department usually likes everyone out of the building by 5 o'clock for security reasons. So if you cannot reach a verdict by 4:30 today, it'll take even if you reach it by 4:30, it'll take time to announce it and everything. So if you can't reach a verdict by 4:30 today, you will have to come back tomorrow at 8:15 and continue your deliberations. Jurors want to know how long should we deliberate. Every case is different. Every jury is different. I've had juries deliberate less than an hour. I've had them deliberate for several days. So it really depends on you and under those individual circumstances. So I just want to let you know that. But if you can't wrap it up today, which is perfectly understandable, you'll be coming back tomorrow about 8:15 as you would a normal day, okay? So that's how we'll handle that. There's really nothing else I can do until Ms. Dilworth comes back, so we'll wait for her, okay? Okay, I talked to them about time control, so I need to swear you in, Ms. Dilworth. Please raise your right hand. Do you solemnly swear that you will, to the utmost of your ability, keep the person sworn as jurors in this trial in some private and convenient place? They will suffer no communication, orally or otherwise, to be made to them, that you will not communicate with them orally or otherwise, unless ordered by the court, and that you will not, until they have rendered their verdict, communicate to anyone the state of their deliberations or the verdict they may have agreed upon. So help you God.
I do.
Very good. All right, at this point, Ms. Dilworth will come back over there. We're going to excuse you back into the jury room. Do not begin your deliberations quite yet. I have to talk to the attorneys about a couple of issues. Usually it takes between 1 and 5 minutes before you begin deliberations, but don't do that yet until we get that word from Ms. Dilworth, okay? I'll rise for the exit of the jury, please. All right, be seated, please. Okay, anything, Ms. Prevette, before the jury begins deliberations?
No, Your Honor.
Mr. Kirkhoff?
No, Your Honor.
All right, very good. They can begin deliberations. We can go off the record. All right, thank you very much, everybody.
Right, watch.